drive over, the wedding's until midnight, it was a late wedding.
Yeah.
Because it was after church on Sunday, and
Yeah.
drive from
Which
here to
Sunday
there.
weddings are unusual.
And so,
Yeah. I don't see a lot of those. Oh, I think that.
and he was amazing. He had
Good.
So I've got 2 more meetings.
and then in the morning to go to Cancun, because we had a storm overnight. The weather held off through the whole wedding. And then it stormed overnight, and half of the people that were there that were the Airbnb.
I told him right
They had no idea. So it was interesting.
I gotta get these fingers.
Yeah, exactly. I plan to stay. Most of the time,
Somewhere, stopping traffic on Highway 8. I go, he was 4 miles outside of town when he got stopped by the fire. So he's here.
So I just have this one comes in, so action.
I just keep waiting for
I swear, I was supposed to eat by like literally 9:30 left with plenty of time, and I was sitting at 2 different flagging stations for 15 minutes.
Oh, yeah, easy.
It was crazy.
It's been bad.
It was awful.
No, that's me, TMI, I gotta get my other one.
I left with plenty of time.
one of the largest.
How's it going? I'm already, so we're sitting at the flag station for about 20 minutes each. I came from the highway area, and I left, I mean, according to my little thing, I was gonna be about 9:30. And I hit highway 8.
No use.
I thought I was just gonna
I would love to hear you.
Oh, sure.
What do you want me to talk about? What do you want me to talk about? What do you want to talk about today? Ideas?
I'm the HR manager.
We have met by video, we've never met personally. How are you? Good.
Yep. I read through, I looked through it. You're in.
So this is successful.
Yeah, we've got a couple out on the summer tour, the forestry.
I was gonna say, they're making competitors possible.
Yeah, so both schools are out.
And the other thing I want to talk about briefly is, as a reception. Oh, I'm sorry, John, I didn't see that.
Oh, yeah.
What do you even say? It's better than the one.
Oh, I know it's comfy. Oh, the comfort one.
6 hours.
There it is.
That's not.
Well, but.
That's all right, I like mine, I'll stay for your birthday. So.
Good for you.
Yeah, all dressed up.
Where are you gonna sit?
I'm just sitting somewhere. I just have my stuff all over.
That's fine, I was just trying to figure out where I should park. Do you want to introduce, you want me to?
You can, because you're up front.
I can, okay.
But you got all dressed up, you put on the suit.
I look good.
I didn't say that.
You didn't say that?
I didn't say that, did I?
I can't even see over there.
Call to order. Rusk County Board of Supervisors for training on June 20th, 2024 at 10 a.m. Roll call.
Sherry Wallace?
Yes.
Ross?
Yes.
I'm here.
Mr. Undershoot. Mr. Coggins.
Here.
Mr. Schneider. Mr. Meyer. Mr. Gorsinger.
Here.
Mr. Caleb.
Here.
Mr. Hanson. Ms. Good. Mr. Willingham.
I'm here.
Mr. Russell.
Here.
Mr. Goodis. Mr. Hampton. Mr. Biller.
Here.
Mr. Zimmer. Mr. Moore.
Here.
And Mr. Wedwig.
Here.
Yep.
11 present, 8 absent. So I guess but there's no motion, no vote. We're present with the quorum, but no motion. Training will be provided by Wisconsin Counties Association with Sarah Dietrich, Costa, and Andy Phillips. Training topics, roles and responsibilities, ethics and conflicts of interest, open meetings, public records, and board rules. You may take it away, Mr. Phillips.
Thank you, Mr. Chair. Good morning, everybody. Pleasure to be back here. I've seen most of you on video over the course of the past 6 months. So it's nice to finally be here in person. I thought with summer here, no issues with travel or anything like that until I hit Highway 8 and I hit the flaggers and the construction on Highway 8, so I made it just in the nick of time. So pleasure to be here. Sarah and I have been doing a lot of discussing, Sarah mostly, with various county boards across the state as we had the election in April, and we were trying to help counties level set with foundational information and knowledge about how counties operate in Wisconsin. I'm an attorney with the Tolless Law, and I'm also privileged to serve as outside general counsel for the Counties Association. And so between Sarah and I, we have, I don't think there's a county in the state that we haven't visited with over the course of our careers as it relates to how their county operates and how counties are intended to operate under Chapter 59 and the other statutes that impact county government. We were here, I wanna say it was, 4 years ago? Is that what it was, Sarah? When we had a similar discussion. And the thing that frustrates me as somebody who works with counties across the state and have for my entire career is that as soon as we have foundational understanding and momentum going forward, we have a plan, this is how we're going to attack that plan, this is what we're going to, then we have an election. So every 2 years we've got turnover, and so it's built-in mechanisms to avoid having continuity that lead to frustration. And so I think it's always a good opportunity every couple of years to have these discussions, and I wanna emphasize the word discussion here. This isn't a presentation, because I've never sat in your seat. I don't know what it's like to be a county board supervisor. I know that you have a very difficult job. I do appreciate that. But if you wanna ask questions, if you wanna discuss with me, debate with me, disagree with me, that's fine. I am very, very comfortable having that discussion and debate, because ultimately it's up to you all as Rusk County Board supervisors to determine this is the way that we wanna conduct our affairs from a governance standpoint here in Rusk County. We have topics here. If there are other topics that you may be interested in, wanna talk about, feel free to throw them out. We are at your disposal today. If there's follow-up that's necessary, obviously reach out. The Counties Association is committed to providing counties with resources so that they don't have to struggle through issues on their own. So just let us know what we can do to help. So with that, let's talk briefly about our agenda. We're of course gonna talk about roles and responsibilities. I'll talk about that. I'm gonna talk about ethics and conflicts of interest. Sarah's gonna handle the open government aspect of this with public records and open meetings, and then I'm gonna follow up at the end with board rules. And I know some of these topics are frankly discussions that I've had with either individual supervisors or your board leadership, again, over the course of the last few months, about where having some ideas that we could use to make things a bit smoother as it relates to your meetings, as it relates to organizational matters and things like that. So when we finally get to board rules, one of the exciting things, and I say exciting as somebody that I realize I'm a total geek with this, and not everybody feels this way, but I find it exciting, is that I worked with a couple of counties over the course of the past few months on really revising and updating their board rules, and talking with Sarah and WCA said, you know what, I think this would be a good opportunity to create a model that we could push out to counties and say, these are the various elements of board rules that these counties have found to be very helpful, and maybe you wanna consider that in your county. And so we have developed a template set of board rules that we're happy to share with you in the event that you decide, yes, let's take a look at our board rules and how we govern ourselves in Rusk County. So we will do that at the end of the presentation. So with that, let's start with roles and responsibilities in county government. Some very basic foundational knowledge. We're different than cities and villages as counties. Our authority emanates from chapter 59 of the Wisconsin statutes. Article 4, section 22 of the Constitution says that the legislature is empowered to create counties and provide counties with powers as the legislature sees fit. That's different than municipalities. Municipalities enjoy constitutional home rule authority. Why is that important? Because at the municipal level, unless the state has spoken, the municipalities are free to organize themselves, exercise their powers without legislative constraint. Counties, on the other hand, have to look to the statutes for the power to do something. And so essentially, that's why you see case after case, attorney general opinion after opinion, suggesting that counties are administrative efficiency or arms of the state or the legislature, because we are. Our authority comes from state statute. Most of that is contained in chapter 59 of the statutes. Unfortunately, even though chapter 59 is dedicated to counties, that's not the only place in the statute that impacts county government. We know, for example, that chapter 46 is very important as it relates to human services, social services, community programs, mental health, things of that nature. We know, for example, that chapter 83 of the statutes deals with our highway departments. And so, even though chapter 59 is dedicated to counties, that's not the only place where we find statutes that impact county government operations. We are individual entities. We have the authority to sue and be sued. We enjoy a status that is separate and distinct from that of the state government. So even though we get our powers from the legislature, we do have a separate political and corporate existence from that of state government. Back in the mid-1980s, there was a process the legislature went through to recodify chapter 59 of the statutes and tried to provide additional clarity and authority to county government. And in that recodification, they adopted 59.03 of the statutes, and that is the administrative home rule statute. We'll get to that in just a moment. But that was very important to provide counties with some level of confidence that they can exercise their powers at the local level to take care of matters as they see fit, independent of getting a specific grant of authority from the legislature. So when we talk about municipalities having constitutional home rule authority, we don't enjoy that status. We nonetheless have what's called statutory home rule authority. That's in 5903 of the statutes. All of the counties in the state, uniformly, they're all governed by a board of supervisors. We have the New York model of county government here in Wisconsin. The New York model is that county boards serve in a legislative capacity as the legislative body within county government. That's much different than the model that we see out west with the commission form of county government. So just because you may have a counterpart or colleague or friend that is a county commissioner or county board member in another state, don't assume that they are serving in the same capacity you are, because it really depends upon what model of county government their particular state has adopted. We have a lot of flexibility as counties to determine the size of our boards. In Wisconsin, the smallest board is 7 members, the largest board is 38 members. Anybody know what the 7-member board is? Any guesses? Washington, no. Washington is actually, I think they're 13. No, not Violet either.
No, it's in the island.
I'm sorry.
The island.
The island? Which one is the island? We have an island?
Well, not per se, that little tip of the, what is that?
Door County? That's part of Door County. Madeline Island is part of Door County.
Okay.
Washington Island, I'm sorry, Madeline's up north.
Yeah.
Getting mixed up with the islands. Menominee County. Menominee County is the smallest. Menominee is actually the only county in the state where they have a combined town and county board. And so they serve in a dual capacity as town board members and county board members. Anybody know what the largest is, the 38? Marathon, that's exactly right. And I think that it is so incredibly fortunate for that board chair, Kurt Gibbs, that he deals with the largest board in the state, plus it's an even number. So not only is it the biggest, there's a possibility of a tie vote on issues. So that's the range that we're dealing with. So as I mentioned before, we enjoy administrative home rule authority under 5903 of the statutes. And if we look at that statute, 5903 sub 1, it's a very broad grant of authority. We can exercise any organizational or administrative power. But that second part of the statute is what's really important, and that's what leads to, frankly, some of the conflict that we oftentimes have with our state government friends. Subject only to the Constitution and to any enactment of the legislature which is of statewide concern and which uniformly affects every county. We see this issue arise in the context of, I'll just put an example out, renewable energy setting. When we're dealing with the regulation of windmills or solar farms. Oftentimes the legislature will adopt a set of regulations that govern the siting of these facilities and govern, frankly, the operation of these facilities, and then counties come in and from a zoning standpoint or land use standpoint say, these are the regulations that are going to apply to wind farms or solar farms in our county. And so then we have a dispute. Did the legislature intend to preempt county authority to regulate in this area, or does 5903 sub 1 apply to give counties the authority to regulate in this area? And I'm oversimplifying the actual analysis is a lot more complex, which is, I'm thankful for that because then people have to hire me to go through that, so that's good. But that is an example of where the legislature will step in and adopt the law. Counties will say we have individual authority to regulate in this area, and there's a dispute. Does this statute apply, or has the state preempted our authority? If you look at 5951 sub 1, there is additional authority for counties to organize their affairs from a governance and operational standpoint as they see fit. And so you have the authority to exercise any organizational or administrative power, again, subject only to the Constitution or a matter of statewide concern that the legislature has spoken on. So one area that the legislature has spoken on is when I mentioned before that the legislature in the mid-1980s recodified Chapter 59, is that they basically said counties have a choice. They can have three options in front of you when you make that choice. You have to be a county executive county, a county administrator county, or an administrative coordinator county. And when the legislature recodified Chapter 59, they did a good job of putting those statutes in succession and made it clear in 59.17, this is the model for county executive form, 59.18, this is the administrator form, and then 59.19, the administrative coordinator form. And when we look at the map that exists currently as it relates to breakdown between the choices counties have made between the three forms, you'll see that in yellow we've got county executive counties. For the most part, those are concentrated in east, southeast Wisconsin, and those are the larger population counties. The exception there, of course, is Portage County in the middle of the state. They have an executive, and I can tell you that since adopting the executive form in the early 2000s, they have had several conversations about trying to transition back to the administrator form. But for the most part, those are the populous counties. It might not surprise you to learn that Milwaukee was the first. They were mandated to have the executive model, and then in the mid-1980s, when the legislature opened it up as an option to other counties came on and made that choice. And then we get to the administrator counties. We've got 33 appointed county administrators in the state, and that's the red shaded areas. Those aren't focused or located geographically in any particular area. I know that in northwest Wisconsin, we've got a significant concentration of those administrator counties. The thing that I think is important to understand is that as we've had time pass, if we look back, for example, at a snapshot in time in the late 1990s, the overwhelming majority of counties were organized as administrative coordinator counties. We have had a lot of migration to administrator counties over the course of the past 20 to 25 years. And some have asked, why is that? Why is it that we've seen counties decide that they want to adopt the administrator form as opposed to administrative coordinator form? And in large part, I think the counties that have made that change, that made that switch transition that way, have recognized the need for professional management within that county for one reason or another. Every county is unique, every county is different, and I know that Rusk County is an administrative coordinator county. I'm not suggesting that that's bad or it's a problem, but I will tell you that just in the 30 years that I've been doing this, the operations within county government have become significantly more complex. We are asked to do a heck of a lot now as counties that we weren't asked to do 30 years ago, much less 50, much less 100 years ago. And so we talk about all of the complicated operations with human services, sheriff's office, general operations, zoning and land use. They are not only complicated, but they are diverse, meaning that there is no crossover in terms of the knowledge base from sheriff's office, from a law enforcement perspective over human services. It's a very complex operation, and I think a lot of boards have recognized that given those complexities, it would be nice to have one person responsible for those operations, so we're going to bring in a county administrator to run the show, so to speak. Again, I'm not saying that Rusk County does it wrong or any of the administrative coordinator counties do it wrong. I'm just suggesting that's the reason that a lot of counties have transitioned over the course of the last 20, 25 years. Then when we look at the 12 executives, 33 administrator counties, everybody else is by law required to be an administrative coordinator county. Okay, you have to select one of the three. And so within the administrative coordinator counties, we have quite the mix. We have a lot of counties, 8 of them, that have an appointed position, administrative coordinator. It's a standalone position where they are the head of the Department of Administration within the county that is responsible for oversight from an operational standpoint over all county operations within that county. I would tell you that having looked at a lot of the job descriptions, ordinances, and resolutions dealing with those appointed administrative coordinators, they function an awful lot like a county administrator. But for whatever reason, the county has just decided we're not going to have an administrator, we're gonna have an administrative coordinator, but we're gonna give them the powers and authority that is otherwise vested in the county administrator. In other counties where they don't have a standalone position, they have some sort of combination where somebody will serve in a dual capacity. We have counties where county clerks serve as administrative coordinator. We have 4 counties where the board chair is actually the designated administrative coordinator, and so on. I will tell you that there's an Attorney General opinion on the books, 01-11, which speaks to the incompatibility in the office of administrative coordinator and the office of board chair or board supervisor. Nonetheless, despite that Attorney General opinion, we still have 4 counties where the board chair serves as administrative coordinator. And so the point of that is simply to say that even though all 72 counties are governed by the same set of statutes and the same rules as it relates to organization, we have 72 different ways of doing business in Wisconsin at the county government level. So let's start with the county executive under 5917. What does that look like? I'm not going to spend a lot of time here because I frankly don't anticipate somebody suggesting that Rusk County needs to move to a county executive model. But if you want me to spend more time on this, I'm happy to do it. But when we think about the county executive, at the county level, they're elected at large by the people, and they exercise authority very consistent with what we expect the governor to do at the state level. So they have the authority to appoint and remove department heads. They make the appointment subject to the confirmation by the board chair. They have the ability to veto resolutions and ordinances that this board adopts, and the board has the opportunity to override those vetoes. The executive is responsible for the budget presentation to the board, and so on. And then we get to 5918, which is county administrator. And we will look at that model. It's created by resolution of the board or by petition and referendum. That administrator is appointed by majority vote of the board. There's no election for the administrator. And so when we think of the administrator model, in my mind at least, it's more similar to a private sector model, meaning that in a private sector corporation, you've got shareholders. Those shareholders elect a board of directors, and the board of directors appoints a president or CEO. And so that president CEO serves at the pleasure of that private board of directors. In the administrator counties, it's not a president or CEO, it's an administrator, and that administrator is appointed by the board of supervisors and serves at the pleasure of the board of supervisors. And so when you look at the functional position, the functional attributes of the administrator, it's very similar to county executive. The administrator serves as the chief administrative officer of the county. And that administrator coordinates and directs all administrative and management functions. That administrator appoints and removes and supervises department heads subject to board confirmation, okay? And so in many ways, the administrator is acting like the executive, but instead of being responsible to the electorate, that person is responsible to the county board. This is important as well, is that when a county hires an administrator, it gives the county the flexibility to find a person that is best fit for the job, and that's gonna differ county by county by county. We have counties out there that have created the administrator position, but also said to the administrator, you're gonna serve as the chief HR officer within our county. We have other counties that have said, we're going to appoint you as administrator, but you're also gonna be the finance director within our county. So there is flexibility even in that position if that's what a county decides to do, okay? But the thing I like about the administrator description within 59.18, which we'll get to the distinction between this and administrative coordinator in the statutes, is that there is specificity within 59.18 about who is serving as the head of the administrative operational arm of county government. And that's good in 59.18. Because when we look at 59.19, remember, if you're not an executive county and you're not an administrator county, you have to be an administrative coordinator county. And we saw great variation in the way that different counties treat that position. The statute reflects why there is that great variation. The statute simply says, that's the entire statute right there on the screen. The administrative coordinator shall be responsible for coordinating all administrative and management functions of the county government not otherwise vested by law in boards or commissions or in other elected officers. Good luck figuring out exactly what that means. There is no way to figure that out. What does it mean to coordinate all administrative and management functions? As I've indicated, there are some counties that have created administrative coordinator position and essentially put them in charge of stuff. That is certainly one way to interpret what it means to coordinate all administrative and management functions of county government. Absolutely. There are other counties that have not created a standalone office or position, but instead said to their board chair, their clerk, their treasurer, their finance director, you're also the administrative coordinator, and frankly, that person has no real independent authority separate and apart from that of the county board. And so they simply act as the go-between on official items of business, frankly, between the state government and the county government, and they move paper around. That's what they do. And then there is a whole lot in between those two extremes. And so, again, counties have the flexibility, even in choosing the administrative coordinator model, to organize themselves and provide that position with the authorities that the county sees fit. Again, not the level of specificity that we see in 59.18 with administrator. There's no question. The statute says exactly, if you have that office, if you've created it, this is exactly what it does. So again, ask, I said, what does the position look like? And what should it look like, frankly? I mean, in Rusk County, I don't know the details of your administrative coordinator position. I don't know the details of how you've organized. I have some insight. I've obviously had the pleasure of working with you all for some time, worked with the Counties Association obviously for a long time. But you need to decide, what should this position look like, and have we adopted the ordinances, the resolutions, the job descriptions necessary to provide that position with the authority that we deem appropriate in Rusk County? So let's back up a moment and talk about this whole legislative model, the New York model for county boards. What does that mean in Wisconsin? Well, if you look at chapter 59 of the statute, county boards, and every county has a county board, those county boards serve a legislative function within county government. If you look at the powers that are granted county boards, whether it be in chapter 59 or elsewhere, it's all about making policy. It's not about directing the operations of county government. It's all about adopting policy. And so when we talk about adopting policy, I think about the most important policy document within county government, which is your budget. Your budget, I understand it's got numbers. I understand it has to even out at the end. I get it. I understand all of those things. But it is a policy document because it speaks volumes to the public about the priorities for Rusk County government and what it is you are going to fund and what it is you are not going to fund, all right? Again, no operational control is vested with any individual board member or supervisor. Instead, you function as a collective whole. You take action based upon votes and direction provided by a majority of the body. So my question is, do supervisors actually supervise anything? And I think the answer is no. The supervisors it's a historical term, and it's tradition to call ourselves county board supervisors, but it's a misnomer because we don't individually supervise anything. All right. So when we talk about roles and responsibilities for the county board, I like to think of the board having two roles. First, I've talked about this, you adopt policy, all right? You make sure that ordinances, resolutions, and budgets reflect the priorities that you've established on behalf of the people that you serve. But then the other function of the county board, and I touched on this a bit when I talked about the administrator model and the accountability between administrator and board, but you have to hold staff and administration accountable for implementing your policy decisions, all right? And so that's the two roles, adopt policy and then hold staff accountable for implementing that policy. And the role is really that of a visionary. How many of you have been called a visionary by somebody other than your spouse in the last 6 months? Right. That ought to be our aspiration, because if we're proactive and we're a visionary and we are adopting policy consistent with the desires and demands of the electorate, we are going to be called visionaries. That ought to be our aspiration. But this was a good example for Chippewa County, which is an administrator county, but I think it's applicable in every county because it's a great recitation of the distinction that the county recognizes between the policy-making function of the board and the operational function of staff and administration. And so I put this here not as something that I'm recommending that you adopt, but it is again, from my view, a really good statement about that distinction between the role of the board and the role of staff. And so again, to the extent you have a lack of clarity or some sort of disagreement, disputes, misunderstanding, ambiguities, vagaries, whatever, in distinguishing in Rusk County between the role of the board and the role of staff, I would suggest you take a look at a statement like this and put it front and center so that everybody's reminded exactly how we view the role of the board and the role of staff in Rusk County government. County board chair, I want to point this out too, is that your county board chair has no operational authority. Your county board chair is not in charge of county government. Your board chair is in charge of this board, is in charge of the legislative body, because if we look at 59.12 and we look at the statutory duties of the board chair, it's very similar to, again, the Speaker of the Assembly. The Speaker of the Assembly doesn't run DNR, doesn't run DOR, doesn't run DHS. The Speaker of the Assembly essentially presides over the legislative body, one branch of the legislative body that impacts state government. Same with your board chair. Your board chair presides over the deliberative assembly, the legislative body that governs Rusk County government. Standing committees. Standing committees are not statutorily authorized to exercise operational control over any particular department within county government. Instead, those standing committees provide oversight for departments, offices, and other entities, monitor performance. Remember the two roles of the legislative body, adopt policy and then hold staff accountable. Committees help tremendously in that hold staff accountable piece by making sure that information is getting to the committees and to the board so that you can make informed policy decisions. You review and make budget recommendations. You consider and advance ordinances and resolutions. The standing committees is where the heavy work is done from a legislative perspective. The standing committees is where we want the vigorous debate and the public input on a particular measure, because by the time it gets back to the county board, in my estimation, it ought to be fully baked. What do I mean by that? You ought to have confidence that the standing committee has taken into account all of the different facts and circumstances that are going to impact the policy decision and reported that back to the board with a solid recommendation. That's what should be happening. We ought to have confidence in that. So the standing committees need to do the very difficult work of really hammering through details on policy development. So again, I asked what is the committee involvement, and this varies county by county by county. And so we're structured as committees of the county board to do a lot of that heavy lifting, to do a lot of the work associated with policy development. We're supposed to know who in our community our programs are impacting and what it is that we need to do from a policy perspective to improve upon those programs. And so again, the committees need to be very heavily involved in policy development. That's much different than our administration, our department heads, and our staff. They're not visionaries unless we tell them they need to be visionaries. They're not focused on long-term strategies. They're focused on day-to-day. They implement strategies and policies that this board adopts. They have a much shorter term vision. It's very detail oriented. We want them to have specialized training so that they can carry out policy direction in the best way that we see fit. They are practicing a profession. They are here for the long term. They have made it their career, their life's aspiration to do what they are doing. As I mentioned before, as county board members, our most important function is to be responsible to the electorate that put us in these seats, and every 2 years, we have a vote of confidence or no confidence in the job that we're doing. That's not the same with staff. And so I think of staff and administration having two roles. First, they have to carry out the policy direction that the board establishes. But second, and equally as important, they have to make you all look good. How do they do that? They give you the information necessary to make an informed policy decision. That's a very important function. Because again, getting back to the complexities of county government, I don't know how any of you all could be experts in every facet of Rusk County operations. There's no way to do it. Respectfully, there's no way to do that. Instead, we have to rely upon our staff to provide us with the information necessary to make those informed policy decisions. And I always get in trouble when I put this slide up, but I'm going to do it anyways. When we think about, and I want you to think about this for a second, and it's going to show my age here because I'm going to talk about a help wanted ad, and I don't think they've had help wanted ads in quite some time. But let's imagine for a moment that we put out a help wanted ad for a highway commissioner. And we say we need a new highway commissioner in Rusk County. And we want that highway commissioner to have an education. We want that highway commissioner to have some experience with county highway departments. We're going to check that highway commissioner's background. We're going to make sure that they're bonded, that they're current on all their professional accreditations. We may ask that they be members of certain societies or associations that are going to impact the job that they do as the Rusk County Highway Commissioner. In other words, we want the best and the brightest highway commissioner out there to come in and oversee the vast operations of the Rusk County Highway Department. Okay? Let's talk about the help wanted ad for a county board supervisor. What does that look like? What are the qualifications to be a Rusk County board supervisor? Anybody?
You're breathing.
You're breathing? Yeah, you gotta be breathing. Yeah, that's a good one. What else?
Be a resident here.
You gotta live in your district, that's right. What else?
I think so.
You gotta be 18. All right, gotta be 18. And there's one last one. What? You can't be a felon. We set that bar awfully high, didn't we? We set it way up there. And a lot of people say, well, that's offensive. I've got all sorts of awesome qualifications in my background that I deserve to be on this board, and I can represent the people here, and I've got some awesome knowledge and information to share. And you're right. You're 100% right. But none of that is baked into the statutes that say this is what you have to do in order to run for county board. Because what's the most important qualification to get in this seat? The most important. Get more votes than somebody else. All right? So that means a majority of the people in your district have decided that you have the privilege of representing them when you get to these county board meetings. And so the most important qualification is the connection to the people who elected you to sit in these seats. And again, that's not to say that we don't have very talented business owners, farmers, lawyers, professionals, members of the clergy. I know we have one here. I get that. We have talented people sitting on county boards, but none of that is a qualification required to sit in these seats, okay? So again, our job is to represent the people that put us here. So again, speaking to this concept of leadership roles when it comes to administration, department heads have a leadership role within their department and consistent with the guidelines that this board has established, all right? Department heads have an obligation, not a choice, an obligation to carry out the policy direction that this board establishes. And just so you think I'm not making all of this up, there have been cases that have advanced through our court system where the court has been asked to weigh in on the distinction between policy and administration in county government. This comes from the case Schutte versus Van de Hey, which is a 1996 Court of Appeals case. The reason I like this particular excerpt is that there are various sources that the court drew from in order to make that distinction between policy and administration in county government. And I don't need to read to you, I know only you can read, but again, I think this is really insightful. The county board's functions primarily policy making and legislative, while the county executive, or county administrator, or administration in general, functions as an administrator and manager. Policy has been defined as a high-level overall plan embracing the general goals and acceptable procedures, especially of a governmental body. Citing right to the dictionary, general understanding of the term. Legislative power, as distinguished from executive or administrative power, is the authority to make laws but not to enforce them, or appoint the agents charged with the duty of such enforcement, citing to the leading treatise on municipal corporations nationwide. The crucial test for determining what is legislative and what is administrative has been said to be whether the ordinance or policy is one making a new law or policy, or one executing a law or policy already in existence. All right? So again, even though, and it'd be nice if Chapter 59 of the statutes was organized like the US Constitution or the Wisconsin Constitution with a clear delineation of the different branches within county government, but it's not. But even though it's not, that doesn't mean it doesn't exist. It's there. Courts recognize that it's there. So let me give you some background on the Schutte case. Schutte was the county board chair, Vanderhays the county executive. All right, and this is Outagamie County, so Appleton area. Outagamie County operates an airport. Around the airport is land that is suitable for agricultural use. County board says, we want to lease this land out for agricultural purposes. County executive says, no way, that's going to create safety hazards at the airport. FAA, they're in business. This is not an issue with federal law or anything like that. So in other words, you can utilize that space around the airport for agricultural purposes, but the executive is saying, nope, we're not going to do it. It's not safe. Who wins that fight? How many people think county board wins? How many people think executive wins? County board wins. That's a policy decision. Are we going to lease the land? That's a policy decision. Here's the kicker. Who negotiates the lease? The executive, all right? That's an example, frankly, of where I think the legislature, whether intentionally or unintentionally, bake conflict right into the statutes. Bake it right in there. And say, you know what? We're not gonna resolve this issue. We're not gonna be able to break every single tie that's out there. You guys gotta get along and figure out how to make this work, all right? So yeah, county board paid a lot of money to litigate a case up to the Court of Appeals. Very, very talented lawyers, by the way, that handled that case incredibly. Yeah, you can smile, it was me, my name's on there. I was 2 years out of law school when that happened, but that's okay. So, county board paid a lot of money to litigate this case to have a court say, yep, you get to decide whether you're gonna lease that property. But you know what, county executive negotiates that lease. And so, I think in a way it was the court, yeah, the court did a good job of distinguishing between policymaking function of the board and administrative function of the executive, but also said, you guys gotta figure this out long term. So what happens if we don't have a clear understanding of roles and responsibilities within county government? This is not a reflection of Rusk County. It's not a reflection of any particular county. This is a list that has been developed over time based upon my experiences, Sarah's experiences with different counties all around the state. If we don't recognize a clear distinction between policy and administration, if we don't have an understanding of roles and responsibilities within county government, we have boards that spend a lot of time on trivial issues. We have boards that are reading reams upon reams upon reams of documents before, during, and after meetings because they have to be informed because they're being asked to make very significant operational decisions. We have long-running meetings that you get done with the meeting and say, boy, I don't know what we accomplished today. And I want to skip down and I want to talk about the item that's in red there because I think this is important. We have boards that are acting reactively to issues that they could have proactively solved. Let me ask you this. Is a visionary reactive or proactive? A visionary is proactive. All right, so if we aspire to be visionaries, if we aspire to have somebody other than our spouse call us a visionary, then we are going to aspire to be proactive as opposed to being reactive. And by the way, this isn't a criticism of county boards, because staff comes into play here too. Because as soon as we have a lack of clear understanding in roles and responsibilities as it relates to the policymaking function, the administrative function, staff figures it out. And staff is gonna do what they do to survive. And so they're going to start meddling in policy decisions that belong to the board, just as much as boards start meddling in operational decisions that belong to staff, all right? So before anybody thinks that the entire presentation is a knock on county boards, it's not. It's not. We have problems that go both ways when it comes down to the breakdown, if we have a breakdown in understanding the distinction. And so before, remember I talked about the administrator model being very akin to the private corporation model. Here we've got an administrator organizational chart, an administrator county organizational chart, and this is very simplified, I get that. But really we have the administrator appointed by the county board, serving at the pleasure of the county board, responsible for all operations within county government. So from an organizational chart standpoint, it's very clean, okay? If we have a problem in zoning, who do we talk to? The administrator. Fix this. That's the directive. If we have a problem within another office, land conservation, clerk's office, whatever, administrator, fix it. That's the one person that we go to. I briefly want to point out, because some say, well, we have interaction, our standing committees have interaction with department heads. There's no arrow as it relates to department head up to committee. Well, remember, again, this is an organizational chart, not a legislative chart. What is the second function of staff is to make you all look good, to provide you with information necessary to make an informed policy decision. So of course, we're going to have interaction between department head and committee. But committee is not giving department head direction on how to run the particular department. The committee is getting information and insight from department heads so to allow the committee to make an informed recommendation on policy back to the board. In counties where we have administrative coordinators, typically we see a lot more interaction between department heads and committees. We typically do not have the same simple chain of command, if you will, between county board to administrator or administrative coordinator out to department heads. And so that leads to confusion, because some standing committees may treat the relationship with the department head differently than other standing committees treat their relationship with their department head. It leads to confusion. But then of course, nothing is easy in counties. We have these things called constitutional officers. Clerk of courts, treasurer, register of deeds, sheriff, clerk, those are examples. And so where do they fall on the organizational chart? They're kind of weird free agents. They're elected by the county at large. They have constitutional and statutory obligations that we as a board can't impact. At the same time, we're asking them to serve in a management capacity as it relates to the operations within their particular constitutional office. And so they have what I like to call a dual persona. They're responsible to the electorate for the constitutional and statutory functions, but they are also responsible to the board and administration as it relates to the goings-on within their department. What do I mean by that? The sheriff doesn't have unilateral authority to set wages for all of the deputies and other staff within his office. Doesn't. Who sets that? The county board, all right? The sheriff doesn't have the ability to implement a new benefits plan or leave policy without this board saying, yes, you can do that, all right? So again, I think that this is another example of some baked-in conflict within the statutes where boards and constitutional officers are forced to have discussion and figure out a path forward. And so what I like to say is that constitutional officers sometimes will complain and say, the board doesn't have any clue what I'm doing. The board doesn't care about my office. And then I'll let board say to me, that constitutional officer is doing a terrible job. He or she wants to hire his or her brother or sister to do this. They don't even show up to work. And I always say, have you had a discussion? What do you mean? Have you actually sat at this podium and had a discussion about everything it is that you do on a day-to-day basis as Register of Deeds? Well, no. Have you talked to the board about 59.43 of the statutes? Have you talked to the board about your obligation under state law to maintain vital records? Well, no. Well, if you've not had that discussion, how can you complain that the county board doesn't understand what it is you do? Do you think that organically they're just going to figure out what the Register of Deeds does? Absolutely not. And then I say to board leadership, have you had a discussion with your constitutional officers about the budgetary constraints that are confronting county government, about the levy caps that we have, about all of the various things that we have to cut, so when they wanna hire 15 new staff members, the answer has to be, no, we can't do that. Have you had that discussion? No. I really want to encourage open and honest discussion between, and I shouldn't just say constitutional officers, it's department heads as well, about the things that are within your sphere of control as it relates to policy and budget, and the things that are within their sphere of control as it relates to statutory responsibilities and the operations within a particular department. I think that's critical. So again, our goal is to try to figure out a path forward. How do we work together? What do we do? Understand roles and responsibilities, and understand the dividing line between policy and administration. Know what it is that we do, and we aren't going to interfere with what it is that they do. And I'm talking on both sides here, staff administration and county board. Devote the time that's needed to do a good job. Read the background materials and information that staff provides. You have an obligation to provide that to you. You don't have an obligation to read it, but as soon as you don't, what do you think staff is going to do? They're gonna stop providing it to you, then all of a sudden, you're making blind decisions. And I think that can be very dangerous. The third bullet point is very important in my perspective. It's okay to say you don't know or don't understand. I, again, don't know how you could know everything. It would be intimidating to me to show up at my first county board meeting, sit in one of your seats, and have presented to me a budget amendment proposal to transfer $500,000 out of contingency into human services to take care of an out-of-home placement. I'd be like, what are you talking about? I have no idea what you're talking about. It's okay to say, I don't understand this, explain it to me. That's why staff is here. Again, we want to make informed policy decisions. We don't make promises outside of board meetings. There are legal reasons that we don't want to do that. But it also leads to a breakdown in the entire policy development process. And so we don't want to have that chaos that comes when we have a breakdown in a policy-making process. We listen to what our constitutional officers and department heads have to say, and we hold them accountable for providing us the information necessary to make us look good. If somebody complains to us, whether it be a citizen or an employee of county government, we're responsive. We listen, but then our job is to go to our Rolodex, and here I'm dating myself again, I don't know how many people have Rolodexes anymore. But we go to our Rolodex and we say, here's who you need to contact to get your problem solved. You don't jump in and solve the problem for them. Again, that would reflect a breakdown in the distinction between policy and administration. And so we want to be a shepherd for that particular citizen or that particular employee, so they're getting good service, but they're directed to the people who can actually effectuate a resolution, as opposed to us who have no independent authority to effectuate that type of resolution. Understand our complaint process and direct folks to that complaint process and make sure it runs smoothly. Staff has an obligation to remain politically neutral. I'm not talking about R&D here. I'm talking about the different factions that develop in county board issues, where certain members of the county board are in favor of something, others are opposed, and vice versa. Staff have an obligation not to take sides. So don't assume that they're automatically taking a side just because they're providing you with their professional recommendation. They probably aren't. Instead, they are focused on what they have been trained to focus on, which is to provide you with the information and recommendation necessary to make a decision. Key points to remember: we're creatures of the state. We don't just get to do what we want to do. We have to follow the rules that the legislature has provided us. We serve as a legislative body as county boards. We set policy, we approve budgets, we levy taxes to support those budgets, and we engage in cooperative decision making. We work most effectively when the heavy work of policy development happens at the committee level. That's where we get input from our department heads, our staff, and from the citizenry, all right? You do a lot of that preliminary work at the committee level prior to making those recommendations, and then the committees, and with recommendations to the board, we monitor performance within particular departments, not only from a fiscal perspective, but from a personnel perspective, from all sorts of perspectives. In other words, you have oversight responsibility as a legislative body over all of county government. Individual supervisors don't manage anything. You have no individual operational authority within county government. Staff has an obligation, not a choice, but an obligation to carry out the policy direction that this board establishes. And I love this word micromanaging. Why do I love this word? Because it's capable of so many different definitions. And I love it whenever I've got a room full, and typically I'm speaking in front of a board, and then behind that board I've got staff. And I say to the board, don't turn around, but how many of you think that you micromanage? Hand or two will go in the air. I say to the board, don't turn around. Staff, how many of you think that your board micromanages? Every hand shoots in the air. What does that tell me? It doesn't tell me somebody's right or wrong. It tells me we've got a difference in the definition of micromanagement. And I don't know who's right. I really don't. It could be that the board's efforts to hold staff accountable is viewed by staff as micromanagement. Or it might be that we've got individual supervisors making daily public records requests of a particular department. That's micromanaging. I don't know what the answer is, but it tells me again that we ought to have discussion within the county, because there is a vast disparity in that definition that is very important. All right, we want to make sure that we have our board understanding its role and responsibility, that we have administration and staff understanding role and responsibility, and that with that common understanding, we work cohesively and cooperatively to provide an efficient form of government to the citizens of Rusk County. And I realize that I'm an eternal optimist that has a utopian view of county government, but I know we can get there. I know we can. And if we can eliminate disagreements and discord over who makes what decision when and how, get that off the table and focus on the important policy issues that are before Rusk County government, I know we can get there. That's possible. We can do that. It just requires a little bit of effort, and it requires discussions. So, with that, why don't I wrap up on roles and responsibilities and see if there are any questions or comments that we have on this? Nothing, we got it down pat. Awesome. All right. I'm going to talk a little bit about ethics and conflicts of interest, but I want to circle back to the discussion we just had when we get to board rules at the end. As I mentioned earlier, we've developed a template set of board rules that speak to the role of county boards and the role of administration, and how having those board rules may help with some of the process. Again, not making any judgment about whether you do it right, wrong, or indifferent in Rusk County, but again, we have turnover every 2 years, and all of a sudden we've got to reinvent the rules. So we'll get back to that at the end of the presentation. All right, let's talk about ethics issues. If it smells funny, you might have an ethics issue. These are important concepts. I love these concepts because these really highlight and underscore the importance of these issues. There is no odor so bad as that which arises from goodness tainted, from Henry David Thoreau. Warren Buffett, it takes 20 years to build a reputation and 5 minutes to ruin it. Absolutely true. So how do we avoid all of these things? Let's talk about that. Let's start with the F word, felony. There are felonies on the books for engaging in unethical conduct. We don't ever want to get there. That would not be good. If you look at 946.13.1a, public officials or employees, both groups, public officials or employees, and by the way, you as county board members are public officials. Every employee that draws a paycheck from Rusk County government is an employee. So public officials and employees may not, in their private capacity, all right, so acting outside of the county, taking the county hat off, private capacity, in that capacity, they may not negotiate, bid for, or enter into a contract in which you have a private pecuniary interest. Fancy way of saying a financial interest, all right? Direct or indirect. Statute doesn't define what indirect means, but I would suggest that simply putting something in your spouse's name isn't enough to get around the statute, all right? You can't have private pecuniary interest, direct or indirect, if at the same time that contract is being negotiated, you're authorized or required by law to participate in the making of that contract or exercise some official function in regards to that contract. What does that mean? That means you can't, and I'll get into this, you can't simply abstain from the vote on the contract. If you have a private pecuniary interest and by law the county board has oversight responsibility on that contract, we got a problem. we have a significant problem because you're authorized by law to take action on that particular contract. So when we talk about the elements of establishing a violation of this particular statute, there are 4 elements that I just went over. And then we have 946.13.1b. And that says that public officers and employees are prohibited from participating in the making of a contract in their capacity as an officer or employee if you have that private pecuniary interest in the contract. So whereas 1A focuses on the private side of your life, 1B focuses on the public side of your life. And those are the elements of a 1B violation. So how is this statute applied? And we've got examples within the slide deck that talk about the application of this statute. But the one that is, at least for me, most particularly usually comes into play is when a county board member or employee of the county owns a business with which the county contracts for goods and services. And I understand that this statute may present particular challenges in particular areas, especially in rural Wisconsin. What do I mean by that? We've got a particular stretch of the road that we just can't seem to find anybody willing to pave this particular stretch of the road. We've got a county board member that runs a paving company. That county board member says, look, we put it out there 3 times, nobody's answered the call on that. I know that we need that stretch of the road paved, so you know what? My company will do it and we're just gonna charge you costs. I don't need to make any money on this, so I'm just gonna charge you costs, let's get it done. That seems innocuous. You put it out to bid 3 times, nobody's responded, nobody wants to do it. We're getting it done. The people of the county need to travel on that road, we need that road paved. That's a problem. That's a problem under this statute. There's no exception under the statute for that circumstance, all right? So we have to be very careful about things that we view as favors for the county may run us into problems under this statute. There are exceptions under the statute, so that means if there is a contract that is worth not more than $15,000, it's okay. So do we make that paving contract for $14,999? You might have a problem under other statutes. You might not get a felony charge, but you're gonna have a problem under other statutes. So you gotta be very careful with that. The consequences are severe, all right? As I mentioned before, it's a felony, all right? Fine not to exceed 10 grand or imprisonment not to exceed 3 years and 6 months or both. And here's the kicker, that contract's void. So as soon as county board member owns the paving company, says I'll just do what it costs, county cuts that county board member a check. County board member is brought up on felony charges, goes to jail, pays 10 grand, in jail for 3 years, and has to disgorge the money that the county paid. And doesn't get to unpave the road. The contract is void. So, the consequences are severe. As I mentioned before, we can't avoid liability in all circumstances simply by abstaining. This is a very, very difficult issue. And I'll get into this more later, but whenever circumstances arise like this, your very first call ought to be your corporation counsel. Your corporation counsel holds the get out of jail free card. And so you go to Rich and say, Rich, here are the circumstances, I need to get out of jail free card. I need to understand ethically what are my responsibilities as a county board member here. And you ask Rich for something in writing to say this is how I should act. Because if you act upon the advice of designated ethics counsel, your corporation counsel, you have the ability to avoid liability, all right? Again, abstaining is not going to necessarily get you there. It's a strict liability statute. It doesn't matter what we intended. Doesn't matter at all. Doesn't matter that we just wanted to do the county a favor, that we were stepping up when nobody else was. Doesn't matter. It's a strict liability statute. As soon as you meet the elements of the crime, you're going to do the time. So, beyond the felonious conduct described in 946.13 of the statutes, we also have a code of ethics for local government officials. That's contained in 19.59 of the statutes. So who's covered by this ethics code in 19.59? Well, it's all local governmental units, which includes counties. And if we look at the people who are covered, it's local public officials, elective officers, county board members, county administrator or administrative coordinator, and a point of office in which the employee is appointed for a specific term, a point of office filled by the head of the local government. What's missing from this? That was there in the felony statute. employee, all right? Employees aren't covered by the ethics code in 19.59. So you gotta remember that, is that when it comes to 946.13, we cover officials and employees. When it comes to state ethics code for local government officials, it's just those government officials. So there are essentially 5 categories of prohibited conduct that are identified within 19.59. The first is the ban on the use of the public position to obtain financial gain or anything of substantial value for the benefit of the individual's immediate family, or an organization with which the individual is associated. And I love it when we start reading these ethics opinions, these ethics statutes, these ordinances, and other issues dealing with ethics, because it all sounds really good and really simple. Well, yeah, I can't use my position as a county board member to get anything of financial gain or anything of substantial value for me, my immediate family, or an organization with which I'm associated. Sounds easy. All right, dig in, tell me, what is financial gain? What is it?
Anything of substantial value.
What's substantial value? Is it $1? Is that substantial value? Ask my daughter when she was 3, she'd say that's huge value. What about $50? What about $100? What about $5,000? All right, so you see the difficulty with trying to apply some of these ethics regulations because we have ambiguities and vague terms that are baked into the statutes. Does anybody know what the ethics board, the state ethics board, is defined as substantial value? $25. Anybody know when they established that? A long time ago. All right? And the beauty of it is the ethics board is that just because something is under $25 doesn't mean it doesn't have substantial value. And by the way, just because something is worth more than $25, that doesn't automatically mean it has substantial value. So it depends on the facts and circumstances in any particular case. Great, thanks. Thanks for the guidance. Significant consequences for violating the ethics code. You're not even going to tell me what has substantial value. All right, so I think a lot of it is, and I'll get to this in a moment too, the smell test. You start thinking to yourself, hey, you know what? I had no problem accepting that little Nerf football from the copier guy who happened to be in the courthouse and tossed it to me. It was a promotional item. It's a little thing that's not an issue. I can take that. But you know what? He offered me 2 weeks at his place in Cancun free of charge. All I had to do was get there. That's kind of a problem. And by the way, there's a lot of gray area between those two things too. So again, one of the key takeaways from this discussion is have a conversation with the corporation counsel. They hold they get out of jail free card so that you can act upon the advice of designated ethics counsel and not worry about having to argue about ambiguities within the statute. Second category of prohibited contact, ban on offering or giving directly or indirectly anything of value. Again, there we see the terminology that's used within the statute. Quote, if it could be reasonably expected to influence the public official's vote, official actions or judgment, or could reasonably be considered as a reward for official action or inaction. All right, that's the second category. Third category relates to political contributions. I'm not going to spend a lot of time on that, but we know we can't have pay to play. That's clear. Fourth category, ban on taking any official action substantially affecting a matter in which the official, a member of his or her immediate family, or an organization with which the official is associated has a substantial financial interest. Again, we see terminology utilized within the statute that is incapable of precise definition. What is a substantial financial interest? How do we define that? By the way, I don't have the answer for you. I don't. That's what's a little bit frightening about these ethics issues. Even though we have this fourth category of prohibited conduct where we can't take action on a matter that substantially affects us, there is an important exception to that rule. It's called the class action exception. I had this issue come up 2 days ago when I was in the county, where I had a board member ask if he had to recuse himself from consideration of a vote on a salary or wage increase for all sheriff's office employees because his wife was employed by the sheriff's office. I said, no, you don't have to abstain from that because you're not voting on an increase, particularly your wife, you're voting on an increase that's going to apply across the board to 27 employees. That's not an issue, that's the class exception that's in the statutes. That's it. But if you want to avoid the appearance of impropriety, you can abstain, you can do that. And that's an important point. is that, remember what Warren Buffett said, it takes 20 years to build a reputation, 5 minutes to ruin it? Do you think anybody cares about the ambiguities in the statute? Do you think anybody cares that you don't think that that item had any substantial value and it really wasn't something that caused you to financially benefit either you or your immediate family? Do you think that the headline in the paper is going to say, county official is awesome at job because this was not really substantial value? Or is it gonna say unethical conduct? And really the consequences from perceived unethical conduct are just as severe many times as the legal ramifications associated with violating ethics code. So the goal should be to avoid all of these situations altogether. Also brings up an important point about this whole concept of immediate family member. I skipped over that, I should have talked about that a little bit. When we talk about the definition of an immediate family member, it's defined in statute as your spouse, an individual related by marriage, lineal descent, or adoption, who receives directly or indirectly more than 1/2 of his or her support from you, or you receive 1/2 or more of your financial support from them. So somebody's brother is not considered an immediate family member under the ethics code unless brother is living with you and getting support from you, or vice versa, all right? And so, again, when we talk about the perception of misconduct, unethical misconduct, do you think the paper is going to draw that distinction with immediate family that's drawn in statute? Or is the paper going to say county board member votes to give lucrative contract to county board member's brother? All right? So again, just understand that the statute defines things a little bit differently than I think the public would, and we want to avoid all perception of unethical conduct. Fifth category, ban on the use of your position in a way that produces or assists in the production of a substantial benefit, direct or indirect, for you, member of your immediate family, or an organization with which you're associated, all right? The statutes don't prohibit us from taking action on salaries, benefits, or reimbursements, or voting on a county or municipal ordinance. That's clear in the statutes as well. But again, we have to be very wary of perceptions in this regard. So what is the penalty if we violate the ethics code for local government officials? We can be ordered to pay a forfeiture of not more than $1 grand for each violation. If it's a pay-to-play situation involving political contributions, that does rise to the level of felony. I don't talk about it here, but the important part too is that there is a fee shifting mechanism to where you have to pay your own lawyer to defend yourself in court. You may be ordered to pay the costs associated with the prosecution of this action as well. So the consequences from a financial perspective are severe, but I will, say that in many cases, the consequences associated with your reputation are even more severe than the financial consequences that we've got in statute. I've said it 5 times, I'm gonna say it a 6th time. You gotta get out of jail free card. It's sitting right in your corporation counsel's desk. And so if you go to your corporation counsel, before you take official action, before you get into ethical hot water, and say to your corporation counsel, here is what I'm dealing with, and I need to know how to act. Provide me with a written opinion about what I should do in this circumstance. Your corporation counsel is going to provide you with a written opinion. And as long as you follow the advice that your corporation counsel provides, they can't come back at you later and say that you violated the ethics code. It can't happen. But you have to follow that advice. And so I would be very liberal in my questions of corporation counsel whenever these situations arise. Liberal meaning I go to him early and often to make sure that I'm not getting myself in ethical hot water. You can adopt an ethics code particular to Rusk County. Do you have an ethics code? I can't recall. So you have adopted an ethics code. You can make that code applicable to not only officials, but also employees. And it has to be, for the most part, consistent with the prohibitions that we've got in state statute, but you can add other things as well, all right? So again, you have the ability to define what is considered ethical conduct in Rusk County for officials and employees further than what they've gone to in 19.59 of the statutes. So this essentially boils down to what I call the 6-part smell test. And if you go through this 6-part smell test, every time you are confronted with a situation where the alarm bells in your head go off and say, look, I may have a conflict of interest or an ethics issue here, ask yourself these 6 questions. And if the answer to any of these 6 questions is yes, immediately go to corporation counsel, all right? And so I know that the statutes are full of vague terms. I know that the statutes at times seem inconsistent, and it's really difficult for you to independently go to those statutes and figure out what to do. And so I've tried to put together the smell test to get at the answers to these very simple questions that would trigger, and I'm gonna say obligation, even though the law doesn't recognize it as an obligation, I think we should consider an obligation to go to corporation counsel for further support, all right? So let's break this down. How does this apply in the real world? Let's say that we have a good friend, let's say you're on the highway committee. You have a good friend who asks for some help in moving some furniture for his church. He'd like a crew of 2 highway employees and the use of 1 highway department instructor. 2 hours, that's it, 2 hours. All the members of the highway committee are also members of the church. And the highway committee's gone on record as supporting the use of the employees in the vehicles as a way of giving back to the community. What do you do?
Don't touch it.
I'm sorry?
Don't touch it.
Don't touch it. This is a problem. We're dedicating county resources for use on something other than county business. Not only do we have ethical issues for those who decide to direct the use of the resources in that fashion, we have a public purpose issue, which means that the taxpayers have given us the resources necessary to perform government function, and as stewards of those resources, we can't take them and put them to private use. We can't do it. So we avoid this situation. Example 2. Your neighbor advises you that her daughter's applied for a job with the zoning department. She's asked that you put in a good word for her with the director and the committee of jurisdiction, of which you are not a member, all right? You're just on the county board. What's your response? What if the neighbor starts inviting you over for cocktails and cookouts while the hiring process is taking place? Can you take the food and the drink? What do you do? Really? I'm taking the free food. I'm taking the free food all day long. And I'm hoping to God that the neighbor never finds out I had nothing to do with the process. There's not an ethics situation here. This isn't a problem. There's a morality issue. What is the morality issue? The neighbor has no idea that I have no influence over whether neighbor's daughter is going to get the job or not. So is it incumbent on me, because I am a good moral person, because as you all know, all lawyers are very moral people? Is it incumbent upon me to say to them, hey, by the way, I have nothing to do with this process? Yeah, it probably is, but we don't have an issue under the ethics code in this situation. All right, final example. An attorney does a lot of work with Wisconsin counties and assists county officials to ensure they comply with the law. Is at a conference where you're also attending. The attorney picks up the tab at the bar. It's a minor expense for some, but a major expense for others. Did you violate the ethics code by not at least offering to reimburse the lawyer? 100% yes. You can't allow me to pick up the tab at a conference. That would be unethical on your part. You're supposed to laugh at that. I do get questions along those lines, especially as it relates to conferences where they will have booth giveaways, where somebody will be at the bar and just picks up a tab that's, $100 for 10, 15 different people, whatever. Well, isn't that an ethics issue? I don't view that as attempting to influence official judgment. I just don't. I'm sorry. If that would influence official judgment, I'll just get in my car with a keg of beer and run around and buy beers for everybody around the state and have every county under a retainer within a 2-week period. That's not gonna happen, okay? So I don't view that as a problem. If I start saying to you, hey, you know what, I really like working for Rusk County, this is really nice. Here are some concert tickets to go see Metallica in Chicago next week. Have fun. That's a problem. That's an issue, all right? Again, a lot of gray area between those two things, but understand that, at least in this setting, I don't view it as a significant ethics issue. All right, we're gonna transition to open government. I'm gonna toss the microphone to Sarah here, who's going to wow you on the intricacies of the open meetings law. Before I do that, any questions, comments, concerns, issues? Restroom? We can take a quick break, I'm good with that. Mr. Chair, you good with that?
Yep.
I don't have the power to declare recess, you do.
You take a 5-minute recess?
There you go. Yes, go for it.
What about, is it abstaining won't make you
Automatically, right. And so it depends upon the circumstances. It depends on what you're abstaining from. And so there are circumstances where even abstaining is not going to get you out of it. Because it's a conflict of interest that is automatically recognized by statute. So you have to be very determined, that's why you go to Rich Corporation and say, look, if I abstain from this, I'm not free from liability. I'll make sure that you have that conversation.
What about if you, and then so, another member is staying, and I asked him afterwards why. Because being, he had asked me,
We should ask them.
Is that related? I think it arises in ethics issue. And I think he was trying to avoid the appearance of favoritism, which is laudable. You should support that. So then I think that you have to get a supervisor about how to best show that we are remaining neutral or withdrawing in a situation where it gets into favoritism. But that's not an ethics issue. So, good luck.
Just flag me down and we'll go hide some, so you have to leave.
Too many of the examples that are here. Are you staying here? I can read it.
We're in.
And do you have anything tomorrow?
No, I'm driving back.
Nice. That's an easy
Oh, okay, she's in second grade.
Yeah, yeah.
First and second. Yeah, she's in second. Tell you, they run that house like a well-oiled machine.
I'll get it, I'll probably give it to you. Let's see what I can do. Let's see what I can do.
I assume a lot of it isn't changing to this kind of stuff.
No, in fact, you'll have the PowerPoint, I just don't know if I'll have the script.
Oh, that I don't need, I need the copy, like I was hoping to copy the PowerPoints this weekend.
Well, that I can do. That I can do.
Yeah, I'm less concerned about that other meeting.
I get it.
Really? Oh, really? She's something, she's she and Brady and then the youngest one, they all took a shot to me. I passed my wife. Yeah, number 17. Well, she's the other way. And so they really monitored her closely. In the last couple, they didn't let her go to California. So I'm guessing they were able to go to August. Trying to get.
Okay, yeah. That's finally
The plan
good.
is for us to stay 2 days a week there. And then
Fortunately, they don't do that.
You have an overnight run. Yeah, I'm not good.
Oh, okay. But she's really good.
Okay.
And she's.
Okay, yeah, there looks like there's 3 attachments to that now.
Yes.
Yeah, otherwise, know that you're good, you have a room, you're on the list.
Area there. All of that.
Yeah, let me do this too.
Taking another. More checking on that to make sure you're gonna be healthy.
Based on what I'm gonna tell you, you know, it's kind of one. Okay. Yeah, I know.
Cause the same people don't talk
Usually people
Yeah, that's it. We're all there. Now it'll be at the top of your, be at the top of your email list. I told it to include all of the attachments. So it should be there, right at the top of your.
Sure.
Yeah, not a problem.
And it's all two.
You had to pay so much money. Your kid comes in, over that amount, so you're gonna, now I can't change it.
in their house, too. Employers do some of which are more. Versus. He wants to argue.
He wants to, do educational constitutional.
Good for him.
He wants law. He told me that. Yes, because
He was over. Made off for pretty Oh, really? You're not giving as many jobs as you should.
That's awesome. That's awesome. Fantastic, good luck.
I was just curious, like.
There you go. I'm gonna make fun of it.
No, we're only
Remember, you
higher
promised.
than expected.
I'm here a few years now. I've been here a couple times. I've talked about some of this stuff too, so I've been here. So.
We're not talking about farm to we're just talking about.
I don't know why we're trying to go.
Yeah. Probably got for the other. Synchronized. Oh, yeah.
And you can see it.
I used to, it was enough when I got drafted to come to the conference the last 2 years.
I was gonna say better ring. We have
The vice chair.
You did? You chop it or you give it? Yeah, there's like 3 day window.
because the, we don't have such a, we don't have when you're anticipating your county clerk is supposed to do that particular.
Well, then the clerk calls around and all the time clerks do that.
This year's been fair. I am so.
Like I'm sure we're over how many years of trying to figure this out, but they're in house around, put everything on. At some point over time.
Yeah.
You don't have enough time.
Which is why you can have overtime.
Can't hear you.
Does he want to join your friends?
He wants to.
Well, 5 minutes
Or
long.
you want to do it right away, or they can go somewhere else
I
first?
haven't decided that. It depends on what he wants to do. Maybe he'll go somewhere else. I just have to teach some stuff.
There she's on.
Yeah.
Sarah, you're on.
All right, good morning, everyone. Soon to be afternoon, still morning though. All right, so let's talk a little bit about Wisconsin open meetings law. Now, the open meetings law is found in chapter 19 of the state statutes, and the law really starts with the declaration of policy. That says that it is declared to be the policy of this state that the public is entitled to the fullest and most complete information regarding the affairs of government as is compatible with the conduct of governmental business. So what does that really mean? What it means is that we have to ensure that we are providing public access to all of our meetings. And we have to do that when governmental business is being conducted. It means we have to provide access to our meetings, when we are making decisions, when we are gathering information, when we are voting on items. And we do that by providing advance notice of meetings. We make sure that our meetings are open and accessible to the public, and we make sure that to the extent possible, we limit the number of closed sessions that we have. To be clear, the open meetings law explicitly provides that all of its provisions must be liberally construed in favor of openness. And we'll talk about all of this a little more throughout the presentation. So the open meetings law applies to meetings of governmental bodies. So in order to know who the law applies to, we need to know what is a governmental body and what is a meeting. So a governmental body, according to the open meetings law, lists a whole list of items, big long list in the statute that says who is a governmental body. To make this really easy for you, it includes you as members of the county board. It includes any body within the county that was created by statute, constitution, ordinance, rule, or order. So again, the county board is a governmental body. Your committees are governmental bodies. When determining whether or not a group of individuals convenes for a meeting that constitutes a governmental body, the focus really is in the manner in which that group or that body was created, as opposed to the type of the authority they possess. So let's say, for example, as a county, you create an advisory committee to study a particular issue. That advisory committee is merely going to be making a recommendation to you as the board. They don't have any authority over the final policy. Would that particular ad hoc committee or advisory committee be subject to the open meetings law?
Yes.
Yes, they would, because if they were created again by statute, by constitution, by rule or order of the board, then yes, they would be considered to be a governmental body under the open meetings law. You are probably going to hear me say this multiple times throughout this presentation and the public records law presentation as well, that if there's ever any question about whether or not something is a governmental body, whether the open meetings law applies, whether or not the public records apply, please make sure you are talking to your corporation counsel or to your county clerk to make sure that you guys are not going to run afoul of any of these laws. So again, we know that what a governmental body is. So now, what is a meeting? According to the open meetings law, a meeting is defined as the convening of members of a governmental body for the purpose of exercising the responsibilities, authority, powers, or duties delegated to or invested in the body. But then the law goes on to say a little more than that. It goes on to state that if 1/2 or more of the members of a governmental body are present, the meeting is rebuttably presumed to be for the purpose of exercising the responsibilities, authority, power, or duties delegated to or invested in the body. So again, what is not considered by statute to be a meeting? Social gatherings. If you all end up at a birthday party, that's a social gathering. That is not considered to be a meeting. Chance gatherings. all of you happen to show up at the local Friday night high school football game, not considered to be a meeting. Conferences, many of you will attend the WCA annual conference, I hope this fall. Your attendance there as members of the board does not constitute a meeting. Now, in defining a meeting a little further, the Supreme Court in the Showers case set forth two different requirements with regard to helping us determine whether or not the convening of the members of a governmental body meets the statutory definition of a meeting. Those two tests are the numbers test and the purpose test. And with Andy Phillips sitting here, Andy talks about the two P's. He talks about people and purpose, but I think the law says numbers, or the AG in this court case talks about numbers and purpose, so.
That's making it easy for people.
He tries to make it easy, he likes alliteration, two P's,
Yep.
people, purpose. Generally though, we'll hear folks talk about it in terms of the numbers test and the purpose test. So, let's talk a little bit about, the numbers test first. So you meet the numbers test. If enough members of a body are present to determine the outcome of an action. Now again, in the previous slide, we talked about the statutory presumption that this test is met if at least 1/2 of a body's members are present. So let's say we have a committee of 5 members. How many members are needed to meet the numbers test? 3? Not necessarily. And the reason for that is because what if you need a vote on your county board, for example, to amend your budget? That's a 2/3 vote. At which point, 2/3 of, say, your county board is 5 is what? 4. You would need 4 votes to pass in that budget amendment if you had a committee of 5 or a county board of 5. And I use these smaller numbers because even though my mother was a high school math teacher, math may not be my strong suit. So how many people? It might take 4 for that item to pass, but how many would it take to stop that action, to stop that budget amendment from passing? Only 2. So the answer is not 3 or 4 if we're talking about a 2/3 vote, but the answer is really 2, because it can take 2 people to stop that particular action. And that is what is known as a negative quorum, which means sometimes less than 1/2 of the body can impact the action and affect the action that will be taken. So you can't always just look at the numbers test and think, oh, it's a quorum, it's 1/2 or more. Instead, sometimes you have to think, could it be less than 1/2? And oftentimes, if you're looking at a 3/4 vote or a 2/3 vote on something, you are potentially looking at, you have to consider negative quorums when you're looking at the numbers test. Now let's talk a little bit about the purpose test. Again, a meeting of a governmental body occurs when the body engages in discussion, information gathering, or decision-making on a matter within the jurisdiction of the body. Now, sometimes this can get a little bit tricky as well. So let's say, for example, your county wants to build a brand new jail. So the law enforcement committee has a meeting that is going on to discuss this new jail. At that meeting, we have the architect, the engineers, the bond counsel, everyone's gonna be at this meeting to discuss it. Members of the finance committee may have an interest in that particular meeting because they know that the bonding for that particular project is going to be run through the finance committee. So a number of members of the finance committee attend the meeting of the law enforcement committee because they want to hear that discussion with regard to the building of the jail project. So, is that a problem? Well, let's go through the numbers test and the purpose test, right? So, it may depend on how many people attend, but let's say it is a quorum or more of the finance committee are attending. Now let's talk about the purpose test. What are the members of the finance committee doing at that law enforcement committee meeting? They're gathering information. And is that considered to be a function of the governmental body by the definitions we've talked about? Yes. So in that particular instance, you not only have a meeting necessarily of your law enforcement committee, but you might have a meeting of the finance committee as well. So how do you handle that? There's a couple different ways. According to the AG's office, they will tell you that you should post a notice indicating that both committees will be holding a meeting. Other times we'll see what is known as a bad key notice put on an agenda of the law enforcement committee
say, you know, a majority of the members of the county board or this particular committee may be attending the meeting of the law enforcement committee. So again, just ensuring that we are providing notice to members of the public that we could have a quorum of one committee attending a meeting of another committee. Again, so if you anticipate and you know that you could have a quorum of one committee attending another committee's meeting, you should make sure that you are providing notice for that as well.
What if they have a situation they don't know each other are coming? 'Cause that's happened.
That has happened.
If they show up where, don't know that they're coming, show up at a committee meeting,
Yeah.
and all of a sudden.
And you don't know.
They don't know that they're all, you know, gonna attend.
No, the Attorney General has said, the guidance there is the Attorney General said, well, you have to ask them to leave. My impression is that I think that we ought to put at the bottom of every committee agenda, county board members may appear at this meeting, they're not required to do so. It may create a quorum of committee or the county board, but there will be no meeting, no official business conducted. That's called the bag key notice, and so I would put that. Yes, I would do that. And I feel relatively comfortable making that argument to a judge if anybody ever complained about that, but just understand that the Attorney General has said, well, we gotta kick people out. And I said, that's contrary to the purpose of what our officials are doing. They wanna be there to be informed. We're going to discourage them from learning about these very important issues. That's absurd. So that's kind of my position.
Yeah, see, that's why you have the lawyer here, right? Because there's differing opinions on that. All right, so let's move on to the issue of a walking quorum. This is probably the issue that we get asked to talk about quite a bit when we're asked to talk about the open meetings law. Now, you know, according to the Attorney General's office, and they have an Office of Open Government that puts out this lovely, very lengthy brochure that tells you all about the open meetings law. But according to them, they say that the convening of members is not limited to situations in which members of a body are simultaneously gathered in the same location, but may include other situations in which members are able to effectively communicate with each other and to exercise the authority invested in the body, even if they are not physically present together. And that is typically what we're talking about when we're discussing a walking quorum. So by definition, a walking quorum is a series of gatherings among separate groups of members of a governmental body, each of which is less than a quorum size, who agree tacitly or explicitly to act uniformly in sufficient number to reach a quorum. So generally, what we are talking about here are methods of communication that resemble or that could have the same effect as a face-to-face meeting. The AG's office talks about simultaneous communication back and forth, instantaneous response, all of those types of things. Even though you may not be in the same room together, all may very well mirror what could happen if you were in the same location. Now, the Supreme Court has talked about the dangers of a walking quorum. Generally, what they talk about here is they say that if all of the work of the governmental body is done through small group discussions, in essence, what is the point of holding the meeting when we already know how everybody is going to vote by the time they get into the room? The other thing that they talk about with regard to a walking quorum is that you cannot use an agent or a surrogate to do your bidding for you. In other words, what we're talking about here is if you want to count votes, for example, you can't, as a member of the body, call everybody and say, how are you going to vote? Because we know that would violate, a walking quorum. But the law goes on, and the AG's office and the courts have gone on to say, you can't ask somebody else to do that in your stead either. That has the same effect. And they say that if you have a surrogate, polling members for you, they have indicated that that does violate the open meetings law. All right, the essential feature of a walking quorum is an agreement among members of the governmental body to act uniformly or in sufficient numbers to reach a quorum. Now it says that if there's no such express or tacit agreement, then you can't have these smaller exchanges. But again, we say just be careful. Be very cognizant about who it is that you are talking to, what it is you are talking to them about, and who they may be talking to after it is that they have spoken with you. The AG's office has a couple of examples that they provide with regard to what is a walking quorum and what is not a walking quorum. So if, for example, you ask your fellow supervisors to sign on to a document asking that an item be placed on the agenda, that is not considered to be a walking quorum as long as you guys have not discussed the issue fully ahead of time. Where it becomes a problem is if you sign on to a document that says that you are committing yourself to a future course of action. Now, the question then becomes, well, okay, we understand how county government works. So how is it then that I can talk to my fellow board members about an issue that I may want to bring before the county board? Now, they will tell you, you should be doing that then as part of a committee meeting or as part of the full county board meetings. Or another way you could get around that is you can send all your communications to the members of the body through another party, such as your county clerk, as long as that ends up being a one-way communication, meaning from the clerk to members of the body and no one else. Now, that being said, there's a lot of things to be aware of. Oftentimes, when we're talking about walking quorums, we're talking about you may send an email to another member of the county board. Well, what can happen to that particular email? It can be forwarded, and you may have had all the best intentions in the world because you sent that email to only one other supervisor. But what if that supervisor hits forward and then somebody else hits forward, and next thing you know, you unintentionally have this thing called a walking quorum? What is the button that if the email does go to the full county board, what is the button that you need to avoid? Reply all, right? Because now all of a sudden, you are at that point, in essence, having a meeting because now you are having a discussion via email between all of the members of the county board. So forward, reply all buttons. Be very careful when you're replying, if you're replying to county related business on your email, that you don't touch those buttons. Phone calls, again, a singular phone call, generally not a problem. The same with conversations. But let's not start a phone tree. Like your church might have a prayer tree. Don't say, I'm gonna call these 3 people, you call these 3 people, you call the next 3 people again, and then all those 3 folks initially chat. That could be a concern as well. Same with texting. Texting is very much like emails these days. You can forward text messages, you can reply to text messages, you can add people to text messages. So again, these are all just things to be aware of where you have the potential to create a violation of the open meetings law. All right, let's skip on to the requirements of the open meetings law. Now we know that the intention of the open meetings law is to provide advance notice of meetings, making sure that they are accessible and open to the public and that meetings are conducted in open session. So how is it that we are required to do that? So according to the open meetings law, the chief presiding officer or the officer's designee is responsible for giving advance notice of the meeting. So that means that the county board chair or the committee chair is responsible for providing that notice. Now we know generally when we talk about this that everybody looks at me and says, wait a minute, what do you mean I as the committee chair have to provide advance notice? I as the county board chair have to provide advance notice. The reality is, I think in just about every county across the state, they have designated that responsibility to the county clerk. And that is absolutely fine, and that tends to be the practice. But by law, the responsibility actually lies with the chief presiding officer. So when you are giving notice, who do you have to provide that notice to? You are responsible for providing that notice to members of the public. You have to provide that notice to any news media who have submitted a written request for the notice. And if your county has an official newspaper, you have to provide notice to their county's official newspaper if you've designated one. And if one has not been designated, the notice should be given to the news medium that is likely to give notice within the area. Now, what constitutes notice to the public? So, notice has to be given through what is known as a posting. And according to the AG's or the Attorney General's office, there are different ways in which you can post. You can post in one or more public places that are likely to be seen by the general public. However, the Attorney General says that you should be posting in 3 public places. You also have the option to post in at least one public place along with posting the notice on your governmental body's website. However, just posting the notice for the meeting on the governmental website is not enough. They talk about how it is a supplement to, not a substitute for, the other methods of notice. Notice may also be given to the public by paid publication in a news medium that is likely to give notice. However, it is incumbent upon you to make sure that the newspaper actually printed that notice that the meeting was going to be occurring. Now, what does your notice need to look like? For most counties across the state, they utilize their meeting agendas for this particular purpose. And if you utilize your agenda for posting purposes, there are certain elements that must be included on your meeting agenda. So probably the easiest thing, date, time, and place have to be included on the notice. Those things are relatively simple to understand. You also need to include on your notice the subject matter of the meeting. And so how detailed do we need to get when we're talking about the subject matter? The courts and in this AG's manual, they talk about the reasonableness standard. I'm not an attorney like Andy, so we just, that legal mumbo jumbo, we just put behind us, pretend it doesn't exist. And instead, the Attorney General says the easiest way for folks to understand this reasonableness standard, or whether or not we're going to meet the requirements of the subject matter of the meeting, is you should ask yourself whether or not a person who is interested in a specific subject be aware upon reading the notice that the subject might be discussed. Now, we know that there are certain types of agenda items that do not meet the standard, such things as old business, new business, other businesses allowed by law, which would there really be anything if we haven't posted it in our notice? No, but we used to years ago see that on some county board agendas. So again, those types of things, old business, new business, they don't really tell us enough. They don't tell us what topics are going to be discussed. So in those instances, those would not meet the reasonableness standard. They also talk about such things as administrators report, board chairs report. The AG's office says that those teeter on the brink of lawfulness, meaning you can put those on there, but they would rather see you list after that the topics that the administrator or maybe the board chair or the committee chair are going to be talking about as part of the meeting. A couple of other quick notes with regard to your agenda. The order of items. Obviously, there's an order of items, and most counties have in their county board rules, a standard order that they follow each and every meeting. Are you required to follow that order? No, you're not. However, just one thing to keep in mind, that if you switch around the order, and something that was on the end of your agenda that folks may be coming a little later for, and it's gonna be a big, huge topic, popular topic, you're gonna, your room's gonna be full of folks wanting to hear about that topic, and it's listed last on your agenda, and you move it first, what might happen? Somebody might miss it. So again, just be cognizant if you're going to move items around in your agenda. If it's something that members of the public might be interested in, you might wanna think twice about taking something up earlier than anticipated. The other thing too, with regard to your agenda items, is just because there's an item on your agenda, it doesn't mean that you are required to take it up. If you place an item on your agenda a week ahead of time, anticipating a particular report to be completed, and that report isn't completed, you're not obligated to talk about the item simply because it was on your agenda. It is okay to not discuss items that are on your agenda. What I recommend you do though, if you know you're not gonna take it up, just make that announcement at the beginning of your meeting, so that if there are members of the public that are present that were interested in that particular topic, they will know that they don't need to sit around for the meeting waiting for that particular agenda item to be taken up, because it won't be. All right, let's talk about the timing of the notice. According again to the open meetings law, you have to provide notice for your meetings at least 24 hours in advance of the meeting. Typically, we see counties providing more than 24 hours notice, but 24 hours is the minimum that is required by statute. Now, there is a good cause exception included in the statute that that if it is impossible or impractical, you can provide notice within 2 hours. I think it is very rare for anybody to provide a 2-hour notice for the meeting. I think I've talked to a few people and said, have there ever been any instances that we're aware of where a 2-hour notice has been provided? I think I talked to somebody in your firm who said during COVID, there were a couple of school districts that used the 2-hour notice to take up some issues related to COVID prior to school occurring the next day. Otherwise, again, usually we don't see very many people use the 2-hour notice at all. Part of the reason for that is there is no definition of good cause in statute. There's also, no court ruling that talks about what constitutes good cause to be able to use this 2-hour standard. Now, when you're calculating your 24 hours, Sundays and legal holidays are excluded. You can count Saturday as your 24 hours. However, if you include Saturday as part of your 24 hour, you need to make sure that wherever you post that meeting is open to the public on a Saturday. So if you generally post in the courthouse and your courthouse is not open on a Saturday, you cannot consider that posting to meet the 24-hour advance notice of the meeting requirement. It also says, according to the statute, that separate notice should be provided for each and every meeting, and it should be given at a date and time that is reasonably close to the date in which the meeting is going to be held. So say, for example, when you had your county board organizational meeting in April, and you guys determined these are all the dates that we're gonna meet as a county board for the next 2 years, can you post it in April of 24 and count that to be a notice for your meeting in December of 24? No, that would generally not be considered to be reasonably close to the meeting date. So again, a single notice listing all meetings would not be sufficient. Also under the law, you have to hold your meetings in places that are reasonably accessible to members of the public. Your meetings have to be held in public locations. They have to be held at locations near the public that is served. Your meetings shall be open to all citizens at all times, unless of course you meet the standards for a closed session meeting, and you also are required to provide access for persons with disabilities. Also, when we're talking about accessibility for meetings, we have to make sure that we have meeting rooms that are large enough to accommodate the citizens who wish to attend a meeting. So again, if you have a hot topic on your agenda and you know that you're gonna have more than 25 people attending your meeting, and you anticipate that there's going to be a large public presence at your meeting, you will need to find an alternate location in which to hold your meeting that will accommodate members of the public. If you are going to be holding a portion of your meeting off-site, let's say for example, you're going to go, there's a few county highways your highway committee needs to take a look at. There may have been some damage, let's say flood damage, and you're gonna go take a look and examine those particular county highways. It is okay for you to go ahead and do that. However, the public also needs to have access while you are at those particular locations and need to be, so access to the public needs to be available in the same way that it's going to be available to you as a board member. In addition, if you are going off-site, looking at these roads that may have been impacted by flood damage, and you guys are all driving together in the car, what should you be talking about when you guys are in the car together? Or in the county van going to check out these locations? What should you be talking about?
Brewers.
The grandkids, the brewers, right? Anything but county business you should be talking about. And only when you get outside of that vehicle, again, at that location, that you're there to look at the road, that is when you can again begin your discussion with regard to county business. All right, citizen participation. According to the statutes, citizens have the right to attend and observe your meetings. Citizens also have the right to record your meetings. However, they can only record your meetings to the extent that doing so does not disrupt your meeting. Citizens do not have the right to speak or actively participate in your meetings. Now, we do know that most counties do allow a public comment period either at their committee meetings or at the full county board meeting. But is a public comment period required by statute? No, it is not. That is a right that you guys afford the citizens of your particular county. If you do have a public comment period, I highly suggest that within your county board rules, you have very specific requirements with regard to how that public comment period is going to be conducted. For example, as part of the public comment period, you should talk about how long is each member of the public going to be able to speak. Is there a registration requirement before somebody is allowed to speak? What can the members of the public talk about during that public comment period? For example, can they only talk about items that are on the agenda, or should members of the public be able to talk about any item that they think is important and that they want the county board to hear about? The other thing I recommend to counties as well is that within your board rules with regard to the public comment period, you also talk about the decorum rules that apply to the county board, and make sure that those same rules of decorum apply to the public comment period as well. Again, as part of the open meetings law, again, you cannot, as a county board member, vote in secret. The only time you're allowed to vote in secret and have a secret ballot is for the election of your officers. So that happens, generally once every 2 years at your county organizational meeting. The open meetings law also requires that you create and preserve a record on all motions and all roll call votes. Again, your written minutes are the most common method that is used by counties to comply with this requirement. Okay, let's talk a little bit about closed session. So if you are going to go into closed session, your meeting notice, which generally, again, in most cases for the county is your meeting agenda, must include a statement indicating that the body may go into closed session. You also need to include on the agenda the subject matter under which the county or the committee, the body would be going into closed session, as well as the specific statutory exemption under which the body is going to go into closed session. When you are going to go into closed session, there's a specific procedure that you must follow as well. First, the meeting must be called to order or convened in open session. Then the presiding officer must announce in open session that the business that is going to be discussed in the closed session, as well as the specific statutory exemption. So that's why it is important, and it's very easy for your county board chair or your committee chair to undertake that step. If you have everything written right there on your agenda, why you're going into closed session and the statutory exemption. Oftentimes we tell the board chairs, just read what's on the agenda to make sure that you're doing this correctly. And then, once all of that is done, there must be a motion made to go into closed session, and a roll call vote is required. And the reason a roll call vote is required is because if somebody questions whether or not you met the reason for the closed session, met the statutory definition, and if you voted no, you may be protected from an open meeting law violation if you voted against entering into closed session. But again, that is not, I would say this is not a license to say I'm gonna vote no on every closed session, that it would not be a good practice on your part. All right, there are many statutory exemptions that have been written into the open meetings law with regard to closed session. Probably most common for counties, you might go into closed session because you are going to serve in a judicial or a quasi-judicial manner through holding of a hearing. You may go into closed session for personnel matters, including such things as employee discipline. You might also go into closed session because for competitive or bargaining reasons, or you might go into closed session for conferring with legal counsel. Those are typically the top reasons why a county board or a county committee may go into closed session. Now we get asked a lot, in fact I think we just got asked earlier this week by a county, who is allowed to attend these particular closed session meetings? The simple answer is those who are necessary for consideration of the matter that is the subject of the meeting. So typically, if you vote no with regard to going into closed session, can you still attend the closed session? Yes, you can. Personnel that are essential to the closed session discussion are allowed to attend the closed session. If a committee is going into closed session, can other members of the county board go into the closed session for that particular committee? The answer is yes, and yet your county has an ordinance on file that states otherwise. When you are in closed session, your discussion is limited to only those items that you announced you were going to be entering into closed session. Those are the only things, again, that you can discuss. You do not reconvene in open session unless it was indicated in your public notice. Oftentimes, what we will recommend is if you are going into closed session and you know that you are not going to reconvene in open session, it would make sense for you to put that closed session on the end of your agenda so that members of the public aren't sitting around waiting for the closed session to get done before you get into the other portions of your agenda. Now again, according to the open meetings law, if you need to vote, you should vote in open session unless doing so would compromise the need for the closed session. So let's say, for example, you guys are going into closed session because you have a parcel of property that you're gonna put up for sale, and as a county, you want to set what your minimum required, what the minimum amount is that you would accept for the purchase of that property. If you did that in closed session or in open session, how much would you be paying for that property? Just that minimum amount, right? So for these competitive purposes, bidding purposes, you would not want to hold that particular meeting or vote on that particular item in open session. Real quickly on electronic meetings, this has become really more of an issue since we had the COVID onset in 2020. Electronic meetings are permitted. Typically when we are talking about electronic meetings, we're talking about such things as video conferences or telephone meetings. You can't hold if you're gonna hold an electronic meeting, again, you have to make sure that that meeting is reasonably accessible to the public. That means that if you have a Zoom link, if you have a call-in number that you are using, you need to provide that same type of access, that Zoom link, that phone number to members of the public so that they have the ability in which to access that information. There are also certain meeting protocols that the Attorney General Office says that you should follow when you're holding electronic meetings. For example, individuals who wish to speak should identify who they are prior to speaking. Otherwise, it might be difficult for members of the public and actually other members of the board to know who is speaking at what particular time. Enforcement of the open meetings law. If there is a violation of the open meetings law, the law can be enforced by the Attorney General, although more commonly, we would see enforcement by your local district attorney. In order for the district attorney to act, the DA must receive a verified open meetings law complaint that has to be signed and notarized from a member of the public. If you are found to be in violation, you could be responsible for paying for reasonable attorney fees. And those, in addition, there's a fine associated with it, somewhere between $25 and $300 for each violation. And you cannot put on your county expense report the $25 to $300 that you may have had to pay for a violation of the open meetings law. And the other thing too, is it could void action that was taken at a meeting that was held in violation of the law. Also, in addition to that, and probably most importantly, if you are in violation of the open meetings law, what's gonna happen? You're gonna find yourself on the front page of the newspaper. There's gonna be that loss of public trust and that embarrassment, which we don't want to see. So, I think that is all I have under the open meetings law, if anybody has any questions. Yeah.
So I had a question from Phil Schneider. He is asking, do you recommend that every time we go into close, we read verbatim off of the agenda? Is that the recommendation?
Yeah, I would recommend doing that, absolutely, because then if it's on the agenda, then it's very clear, and the chair of a committee or the chair of the board, it's easy for them to know what exactly it is they need to be announcing by law. If it's on the agenda, just read it.
Okay, thank you.
That's what we, Ashley, that's what we do at school board.
Okay.
Just nice and easy, and you don't have to remember anything. Nobody's gonna call you on it.
If it's a hot issue or not.
Yeah, if you don't know that it's going to be a hot issue, and you couldn't have anticipated that the members of the public were coming, then that's fine. If there's a way to make an accommodation that evening, that's fine. Otherwise, if you didn't know, I don't think you'd be in violation if you didn't know. Mr. Chair, do you wanna go on, or do you wanna take just a couple of minutes?
Take a couple of minutes.
Okay.
I'm gonna eat, you're not. How about that?
Go right ahead. I just see everyone's getting up anyway. I'm
Very
like,
hungry, step up,
I'll take a couple minutes. Grab the pizza.
Thank you. I'll wait for everybody else to go. I'll be the polite lawyer.
Sarah, you better grab some.
Oh, that's okay, I will wait.
Sarah, I got Kristen on the agenda.
Oh, she did.
Yeah, I forwarded it.
Okay, good. So we know where we're going.
I said, is there an agenda for it? She said, oh, it's just this simple, and I hope it's something that's fine, it's just makes sense to us.
Yeah, I like, you don't know.
Thank you all for the pizza. This was very nice. This one's quicker, the public records ones.
There's not very many slides to it.
Haven't had any issues with public records out here, right, Tom? None.
Part of the thing is, there's a lot of parts of it that they don't really have to know, because they're not like big custodians. You know, I mean, they are, they're authorities, but generally they designate their responsibility to the clerk. So they don't have to know. You have to have the courthouse open this many hours to, you know, those kinds of things. I don't know
All the details.
the details. Again, if you're a town, that's all different.
It's a lot different.
Because you know, your county courthouse is opening at 4:30 every day, so people can come in at any time. If you're a town.
You're operating out of your house.
I don't know. Yeah, out of your house, or the town hall is open for, you know, 3 hours a week, or.
There's no,
So, yeah,
there's no patches.
it's a whole different consideration. So for towns, it'd be a lot more.
Yeah.
Yeah, no, I'll do that, and I'll make it up on it.
Oh, I can help you.
Right now.
Do you want it? I don't know, Bill.
Stanley?
Yeah.
You guys got Stanley?
No, this is my Stanley Cup that I put a sticker on.
Oh, I thought it was branded.
Yeah.
So I had the Yeti that's branded.
Yeah. Yeah, I've got that. No, we don't have official Stanley Cups for the office. I just put a sticker on it because I think I do that like when I go places or exhibit places, I show it not only here, but it's also on my computer too.
Nice.
So,
That works well.
and I go to the town report conference again and exhibit.
Oh, yeah,
I
great.
didn't have stickers. Did I have stickers on them? I did have stickers. So I quickly put one on my computer so I can demonstrate how it gets used.
How cool it is.
I know. I got it. One supervisor has it on their computer.
There you go.
Sticker.
I actually like that graphic, whoever came up with it.
Yeah, I don't know.
I actually like it because that was on the shirt show once and I really like it.
Yeah. And actually I don't think it was us. I think it was a company because, yeah, you could buy shirts before we started doing it. That looked like, there were some on State Street.
I like that because I have the shirts and so whenever I say like to the kids, oh, I'm going to Polk County, where's that? Oh, here.
I know, I just pull out my cup and I say, here, this is where we are going. We're going here. All right, you ready?
Ready to roll,
Okay, alright.
whenever you're ready.
Nope, that's fine. I'm just gonna put my cup here to demonstrate what you can do with your stickers that we've provided to you today.
Yeah, I'll go right home and do that.
You need
It's
a cup-
also-
You need a cup first to put it on.
You need to come first, I know. I also have one on my computer up there as well, so. All right, let's talk a little bit about Wisconsin's public records law. The public records law is actually a relatively, it's also found in chapter 19 of the statutes. There's, I think, at least a 77-page Attorney General's Office of Open Government document that talks about the public records law. I'm not going to get into a lot of detail about the public records law, nowhere near as much as say, oh, Andy has a friend.
It wasn't my friend.
So, but I wouldn't talk about it in as much detail as say maybe Andy would. Again, not being an attorney, I tend to look for things that, what is it that you as a county elected official need to know about the public records law? So I'm gonna focus more generally on a broader overview of this particular statute. So again, Wisconsin public record law, it is really designed to shed light on the workings of government and the acts of public officers and employees, to assist members of the public in becoming an informed electorate, and to serve as a basic tenet of our democratic system by providing opportunity for public oversight. The public records law, again, as we talked about with the open meetings law, shall be construed in every instance with the presumption of complete public access consistent with the conduct of governmental business. So in other words, in the same way we talked about the open meetings law requiring that we be open and transparent, the same principles apply to the state's public records law. The state's public records law authorizes requesters or individuals to obtain copies of records that are maintained by government authorities. Now you'll notice here, the words records and authorities are quoted. The reason they are quoted is that there are specific statutory definitions regarding records and authorities that we're gonna get to in just a moment. But again, as we talked about earlier, the public records law shall be construed in every instance with the presumption of complete public access consistent with the conduct of governmental business. That means that generally speaking, we can deny access to records only in acceptable cases. It doesn't matter who it is that is making that records request, and the reason that they are making that request to us, it should not matter. And all records are presumed to be open to inspection and to copy. So, excuse me, so let's get into some of these particular definitions. The first definition we're going to talk about is the definition of authority. Again, 19.32 of the statutes has a very lengthy listing of who is defined as an authority. And again, if you are one of those, if you fall into that list under 1932 sub 1 of the statute, you are deemed to be a specified entity having custody of a record. To make it easy for you, local elected officials include local offices. All of you guys are considered to be an authority under the public records law. Also under the public records law, an elective official is the legal custodian of the records, but you may designate that particular responsibility. Not only is an elective official considered to be the legal custodian of their particular records, but if you are the chairperson of a committee of an elected officials, you are also considered to be the custodian of those particular committee records. Now, as we talked about earlier, with regard to providing notices for meetings, very similarly, under the public records law, more often than not, counties have designated their county clerk, or in some instances, the county corporation counsel, to serve as the legal custodian or the records custodian for their particular counties. At that point in time, typically what happens, and I hope you guys have a policy in your county that talks about this. I was in Price County talking about this the other day. The Price County policy very, very easily states, if you as a county board member receive a public records request, forward that request to the county clerk's office, and it is the responsibility of the county clerk to fulfill that records request as your designee. And I'd be willing to guess most counties don't have county board members looking for records. Instead, it is likely your county clerk or your corporation counsel that serves as the record custodian and then would be required to carry out the responsibilities under the public records law. The other definition we have here is the definition of public record. and a public record is defined as a record of an authority. Now, I love in statute these circular definitions, right? A public record is a record of an authority. Still didn't really tell us what is a record. So let's talk a little bit more about what is a record and what is not a record. So a record is defined as any material on which written, drawn, printed, spoken, visual, or electromagnetic information or electronically generated or stored data is recorded or preserved, regardless of physical form or characteristics, which has been created or is being kept by an authority. Now, the important point to remember here when we are talking about what is a record is it is not the format that the record takes that is important. Instead, it is the content. That is what is key when we're talking about records. So let's talk a little bit about some particular examples here. Is it a record? Is it not a record? Here is a list of things that are not considered to be a record. Drafts, notes that you take for personal use. I don't know, I'm very old-fashioned. Andy talked about, putting in notices and papers for jobs. I think I'm even older than Andy. So
Yeah, you are. You're very much older.
I'm very much older than Andy, yes. So therefore, I'm a paper and pen person. So when I'm at a meeting, I am not typing on an iPad. I may be writing down notes on my agenda that I want to, in case I want to go back and look at them later to clarify for myself what happened. Those notes I took on my agenda, I'm using them for my personal use, they are not considered to be a record. Any preliminary documents, drafts, are not considered to be a record. Now the consideration may be different if you choose to share those drafts or those preliminary documents, but if you're generally using them for your own use, they are not considered to be a record. Materials that are published and that are available for sale or that somebody can find at the local library, those are not considered to be a record. Purely personal property of the custodian, and if that property has no relation to your governmental office, that is also not considered to be a record. Material with limited access rights, whether it is copyrighted or patented as a patent, those things are not considered to be a record either. Now this list, what is considered to be a record? If something is in your possession that was not created by the governmental body, but is in the governmental bodies or authorities' possession, those things are considered to be a record. Your personal emails, your personal text messages, calls, documents on your authorities' accounts, they are considered to be records. So if you have your county email address and your county email account, and you have personal emails on there, are those considered to be a record? Yes. But are they disclosable? That's a different question. Business emails, texts, calls, and documents that are on your personal accounts. If they are purely personal, on your personal account, it is not considered to be a record. But if you are conducting governmental business on your personal email account, on your personal cell phone, those items are considered to be records and could be disclosable. Now, you see I have text highlighted here because that's going to be my reminder to tell you a little story about what happened at the City of Madison Common Council. The City of Madison was holding a Common Council meeting. There were a number of reporters in the room. During the meeting, the reporters started noticing that there were members of the Common Council that were taking out their personal cell phones and appeared to be texting in the middle of the meeting. They started noticing that they'd be looking up at other members of the council and give them a look. The other member would pick up their cell phone, look, start typing something back. Again, these were their personal cell phones. After the meeting was done, what do you think the reporters did? They made a public records request to say, I want to see the text messages of those Common Council members that were texting during the meeting. And they ended up taking this to court because the members of the Common Council were trying to argue, this was my personal cell phone, this was my personal, text messaging, you didn't have access to those records. The court said no, because again, it is not the medium or the format or the location that mattered. Didn't matter if it was on the personal phone, but it was the content. And the content of those text messages dealt with governmental business. So what do you think that the reporters did as soon as they got those text messages? They were printed in the front page of the newspaper. And I will tell you, they were not very kind that things that were printed. They were talking about other members of the Common Council. They were saying, hey, I need your help. I can't be the only person here who is, who can be arguing this issue. You need to step up. So these are the types of things you don't want splashed across the front page of the paper. So again, just because you may be using your personal device doesn't mean that it is not a record and it may not be disclosable. The same, applies to social media. Now, I am not real great with social media. My kids call me boomer, laugh at me all the time because I don't understand how Facebook and Twitter and all these things work. And if I'm supposed to download something or do something with it, I have no idea. I have to ask one of my kids. But if I were to post something about governmental business on my personal Facebook page, on my Twitter account, which is now X, if I had a website, all of those things would be considered to be records. Contractor records are also considered to be records. Police body cam and dash cam video, again, all of that is considered to be a record. Probably the biggest thing I want to point out here is if you guys have issued to you a county electronic device, if you have county email addresses, please use those devices. Please use your county email address when you are conducting county business. The reason for that is if somebody makes a public records request, do you want your county IT department to be looking at your county email address, or do you want the county IT department to be looking through your personal devices and through your personal emails to search for records that may be responsive to that particular request? So again, we can't stress enough that county officials should be using their official email addresses for official business. When you do that, it means all the communications are held somewhere in the county's IT site, wherever the cloud or wherever it's all stored, and it makes it much easier for your county clerk who has to respond to a records request to know that all of the relevant records are all included on the county's devices, and they don't have to start asking supervisors, do you have a responsive record on your cell phone? Do you have a responsive record on your personal email? So again, that's why it's very important for you guys to make sure you are using your county devices or your county email addresses. All right, let's talk about a records request. Generally, any person can make a records request, or a person can ask to inspect or copy a particular record. When that person does so, they are not required to identify who they are. They are not required to let you know why it is they want the document or how it is that they are going to be using that particular record that they are requesting. You cannot consider their motive when you are determining whether or not to fulfill a request. When somebody is making a records request, they can make it verbally or they can make it in writing. However, there are no magic words that somebody has to use in order to fulfill or to make that records request. They don't have to cite public records law. They don't have to cite chapter 19 of the statute. There's no magic words. If they ask for a record, you need to work through the process. No specific form may be required. Now, that's not to say counties have not created forms that counties use in order to make it easier for them to fulfill a records request, but you cannot require that somebody use that particular form when requesting a record. When the individual is requesting the record, they must reasonably describe the record or the information that they want. It can't be, what we mean by that is your county clerk should not have to guess what it is that an individual is looking for when making the record request. So they have to be able to reasonably describe the record that they want. They also have to be reasonable as to the time and the subject matter of the request. All of that is to make sure that people aren't going on fishing expeditions. So in other words, somebody cannot come in and say, I want the emails for every county board member on any topic for the last 5 years. That's a rather unreasonable request, and honestly would burden the custodian. Then it would make it at that point very difficult for them to perform their typical daily functions. But if somebody were to come in and say, I would like the emails from a particular supervisor or these particular committee members for these 10 days related to this particular subject matter, then that it would be a little more reasonable as to time and to subject matter. But again, you cannot just, you can't go on a fishing expedition and ask for every single record to be, provided, and in the hopes that somebody may find something. That is just not allowed under the statute. Now, again, there's lots of other things that are included in the law as well that the county needs to be aware of in terms of having, posted your county's record policy within, the county, making sure that, there are specific times in which, in hours, that somebody can access records. Generally, those are things that aren't a problem for a county because your county offices are generally open 8 to 4:30 or whatever it may be, 5 days a week. Becomes more of an issue for a smaller town that maybe doesn't have a town hall that is open with regular hours. But generally, for purposes of counties, a lot of that other stuff, we don't necessarily have to concern ourselves with too much. Now, if you receive a request, you must respond to that request if a responsive record exists. You either have to fulfill the request or you can deny the request. Now, if a record does not exist, there is nothing in statute that says that you have to let the individual know that the record does not, or a record does not exist. However, I highly recommend if a responsive record does not exist to a request, that you let the requester know that there is not a responsive record. With regard to how quickly you need to respond to a record's request, the law does not have any specific time limits included, and oftentimes it will depend on the circumstances. They say you should respond as soon as practicable and without delay. Well, what exactly does that mean? Is that 1 day? Is that 30 days? Is it 60 days? What does that mean? The Attorney General suggests that you respond to most records requests within 10 days. Now, that being said, depending upon the volume of records that were requested, if you have to redact records, it may take you more than 10 days to respond to that particular request. And if it is going to take longer than 10 days, again, it is probably good practice to make sure that you let the individual that requested the record know that you have received the request, you are working on complying with the request, but because of the volume of the material that they asked for, or because redaction is involved, it may take a little longer for you to reply. When you are responding to a records request, only records that exist at the time of the request are required to be produced. So if there is not a responsive record that exists, then there is no record to turn over as part of the public records request. You are not required to create a document or a record in order to respond to the request. Also, when you are responding to a request, if somebody asks a question, you do not have to answer a question or create an answer to a question. Again, if a record exists, you produce the record, but you do not have to create the record. Now, there are some limitations, however, on what you have to provide and what you don't have to provide. There are, the statutes provide some guidance on this. There are published court decisions that talk about this as well. Then at some point you will apply the balancing test, and I think that's the next slide. But there are some things that we know we do not have to provide access to. For example, probably some of the most common things is when we're talking about, identifying information with regard to county employees, whether it's a county employee's social security number, their home address, their phone numbers, their personal emails. Those are the types of things that you can limit access to. All right, now, so once a request is received, and that request, if you've received the request as a board member, hopefully you have forwarded that request immediately on to your county clerk, who likely is your custodian and will be responsible for and has been designated to respond to those requests. So, when your county clerk gets that request, the clerk needs to be asking, does a responsive record exist? If no responsive record exists, then that's it. But if a responsive record does exist, then we need to ask, is there an absolute right to access? And there are certain documents under the law and under court opinions that folks have an absolute right in which to access. In the same tone, you also need to ask whether or not access is absolutely denied. Again, there are certain situations based on court cases, based on state statute, where there's an absolute denial to certain records. Some of those things include, information related to an investigation of, say, employee misconduct, or plans or specifications for certain state buildings, and I'm guessing you probably don't have to disclose, what your county jail looks like as well, again, for safety reasons. So there's certain records that just for safety or other reasons that you would not need to be, providing to members of the public. And then you need to apply the balancing test. You have to weigh the public interest in disclosure of the record against the public interest and public policies against that particular disclosure. Now, if you are going to deny a request, your reasons for denial must be very specific and very sufficient. If somebody makes an oral request to you, you can deny that request for the record orally. If somebody makes a written records request to you and you are going to be denying that records request, you need to respond to that request in writing. Your response needs to include very specifically the reasons why it is you are denying the request. And that is important because you are also required in your written response to let the individual or the requester know that the denial is subject to court review. And when the court reviews whether or not, and if the court reviews whether or not that denial was appropriate under the law or not, the only items or reasons for your denial that the court is going to look at are those things that you have included in your letter. So if you didn't write a very good letter indicating and listing all of your reasons for denial and something else pops up, the court generally will not look at that. So again, oral request can be denied orally. Written request needs to be denied in writing, explaining the reasons and advising that it is subject to court review. You can recover costs for public records requests. Costs for copying, transcription fees may be charged. You can charge the actual necessary and direct costs only. The AG's office a while ago actually undertook an exercise to determine what their actual cost was of fulfilling records requests. So when you're thinking about costs, you may want to take a look at the work that was done by the AG's office. I know as part of that, the AG's office does say that you can't find the highest paid employee in the county and charge their hourly rate for fulfilling that request. You need to generally look at the lowest paid employee if you're going to be charging costs. You can also charge for location costs for the records if that location cost is going to be greater than $50. One thing that you cannot charge for is you cannot charge an individual for redacting records. That is not a charge a cost that you can recover. And if the cost of the records request is going to exceed $5, you can ask an individual to prepay that. So for example, you say to somebody, look, we're happy to fulfill your request, a responsive record exists, it's going to cost $100 for us to get that record for you, and we need you to prepay that $100, they have to prepay it before you need to go ahead and do the work. Otherwise, you can be doing an awful lot of work, you can give somebody the record, and you may never get paid for that. So again, you can't charge. Now enforcement, if somebody, really the remedy for this would be court-ordered disclosure of the record that you denied disclosing. Also, you'd be required to pay for the requester's attorney fees and costs. There could be some punitive damage involved if you are arbitrarily delaying or denying a particular record. And again, as we talked about under the open meetings law, there's also the loss of public confidence in the government if you you know, if you are found to indeed be in violation of the public records law. The last few slides I put up here, I just included, as a reminder that obviously social media, we're tending to hear at the association more and more about social media and how social media interacts and interplays with the open meetings law as well as the public records law. Andy did an in the boardroom for us a couple of months ago with regard to that. And so that in the boardroom can be found on our website. So rather than talk to you guys for another hour or have Andy talk to you guys for another hour about this, I want to just bring to your attention that in the boardroom does exist and it's on our website if you want to learn a little more about social media and public records. Again, I think a lot of what we talked about generally is included in this in the boardroom with regard to, you know, governmental information being on your personal, either on your personal Facebook page, what have you. So again, that is what I have, unless anybody has any questions.
Okay, so I know we can charge for cost to locate, but only if that exceeds $50, or is that?
Only if it exceeds $50.
Okay.
So the $5 is just for
The
copy.
$5 is for the copying, but there's a transcription cost involved. Location cost can be if it's over 50.
Sarah, the open records or requests and everything, I think the initial law and everything was good, but it's kind of been turned into a weapon now with numerous open records requests of really nonsense stuff, and that's basically to harass elected and appointed officials and just inundate them with one request after the other that, I mean, and no answer serves anything. Is there any future legislation or anything can be done about it? Because it's taking people away from their jobs, and then they get charged or accused of, well, you're not doing your job. Well, of course not. We're filling all these, should we say, frivolous things that really have no basis for it. It's just to kind of harass or threaten public and elected officials. Is there anything being done about that, or anything to?
I was gonna say, I'm gonna have Andy address it, cause I know Andy's been involved in a number of these cases where there have been.
That's a great point. We've seen that. Public records law was adopted long before any of the technology we have today existed. We have records of everything now. We have a digital footprint, we have a legit footprint, we have a written footprint, we have footprints everywhere that didn't exist when they adopted this law. And so what we're trying to do is apply a law that existed pre-technology to law that exists with technology. And it's a pain in the butt. Call logs on our personal cell phones, text messages on our personal cell phones, emails, the metadata in emails, all of that stuff is subject to a records request. And people know that they can irritate the heck out of you by just submitting those things. What have our courts said? That one of your primary responsibilities as an authority under the public records law is to respond to public records requests. And so the court elevates that responsibility to be even with your duty as a public official to represent constituents. That's maddening. It makes no sense. It's nonsensical. And I would say if you polled 99 members of the legislature and asked them, do you think this is absurd with the weaponization of the public records law? You would have 99 people do the same thing you just did, shake their head. They'd say, yep, or nod their head. I think that's right. Shouldn't be weaponized. But the second you introduce any piece of legislation suggesting that we need to update the public records law to take away weaponization, what's the accusation? What are you trying to hide? We need to have transparent government. And our citizenry, I shouldn't say everybody, but there's a significant aspect of our citizenry that believes that it is their right to know every detail of your life. Because you ran for county board, that's why you're getting the big bucks, all right? You're getting the big bucks. I deserve to know everything that's going on in your life. And then the legislature says, I don't want to be accused of trying to do things behind closed doors. And so nobody touches it. So I don't know when that's going to get resolved. I mean, we've had several conversations at the county association saying, we really need to do this, or we really need to do this. And everybody agrees it's a good idea. We even have informal conversations with legislators. Yes, that makes a ton of sense. Can we draft a bill? No, are you out of your mind? I want to win re-election. That's what happens. And so we just kind of have to deal with it. And unfortunately, it is part of our job, and it's a very important part of our job. And so I, for one, am thankful that there are these confusing issues. Why? Because people have to pay me to take care of them. So I guess I should celebrate the fact that there's confusion. But I don't, because it's absurd. And I wouldn't call them friends, but people I get along with on the other side who are part of the Open Government Initiative or whatever acronym they come up with for today. They're nice enough people, but they just have a very different view of the world that I will never understand. And as a person who has dedicated his life to counties for the past 30 years, it's entirely frustrating. So I get it, totally get it. All right. Other questions?
I have from an HR standpoint where I get really confused is when a record, there's been a record and a question. So I give the record, somebody that wants it, but then they have a multitude of questions. They're not necessarily asking for a record, but they're asking for questions based off of what I gave them. So when is that still a record request versus?
Well, under a strict interpretation of law, if there's a record that is not responsive to a request, you can say I don't have a record that responds. But I always talk with counties and clients and say, can we just short circuit this entire process if they say, how many employees do you have that start with the last name S? Whose last name starts with S? I suppose we could scour through records to find a roster and then send them the roster and stuff. Or we could just pull up the spreadsheet, count the number, and give them the number. I mean, so I always encourage in that situation to work with the requester and say, what are you really getting at? They don't have to tell you. The law doesn't require them to tell you who they are, why they want the information. I get it. But it's worth a shot, it's worth a dialogue. As I spoke before, the people I get along with that are on the other side of this equation, oftentimes we'll get a request and it's a very extensive request. I'm like, this makes no sense. If I produce all the records that they're requesting, they're not gonna get the information that I think I know that they want. And so I'll call them up and say, what are you after? What do you really want? What do you think happened and how can I help you? We have an obligation to respond. I'm not gonna hide anything, but what are you after? And so I think it just depends again on the particular facts and circumstances of each individual case about how far you wanna go in that understanding that we have no legal obligation to answer interrogatories. That's a litigation term where the other side will submit questions that by law you have to answer. We don't have to do that. The Public Records Law doesn't require that. It's not the Freedom of Information Act, it's the Public Records Law. Okay, we just give them records. But that said, there may be a quicker route from point A to point B to get this done and over with, so we're not investing all sorts of time, money, and resources on responding to a records request. So it just kind of depends. Other questions? Yes, sir.
I understand the issue of maybe a proliferation of public records requests and how that could affect county government, et cetera. And you used the term weaponization, which seems to me like the word weaponization is becoming weaponized. But I don't think that the fact that there may be people who make frivolous requests for purposes of annoying or harassing other people should not be assumed that when a person makes a public records request, that that's their motive.
Absolutely.
And people should not be treated rudely or be vilified
or dismissed
simply because they make public records requests, and we assume that they have bad motives. So I think that cuts both ways, and your suggestion of trying to find out what people really want to know or what information is really important to them for their purposes may be a way to alleviate some of that back and forth.
Well, let's remember the public isn't well versed in public records law either. They might have seen a couple of statements here and there and think that they're entitled to certain information. They use that verbiage in the records request, you get it, and it's really comprehensive. And it's like, wow, this sounds really official, and in reality, they're just parroting something they heard. Having a conversation oftentimes, yeah, I just want to find out which employees you have whose last name starts with the first letter S. Okay, if that's all you needed, I can either send you the spreadsheet which shows that, or I can just tell you it's 14. What do you want? That's a short circuit way, and again, 9 times out of 10, that person's gonna be happy. They're gonna feel like they got good customer service. That's what we want with our citizens, is people feeling good about Rusk County government and the way it operates. And so that's win-win on all sides of the equation. But then you'll have 1 out of 10 that say, nope, I want you to download that complex database with all the algorithms that calculated the number of people who have a last name that begin with S, and I want that full database. All right, you're gonna be difficult, so I'm gonna comply with the law. I'm gonna be difficult too. I'm gonna stick to the letter of the law, and that's what I'm gonna do. That happens too. Overall though, you're right. We can't assume that somebody has bad motives simply because they submit a records request. We don't know. We have an obligation. It's not a choice, it's an obligation to respond to each and every records request that comes to us. I'm just suggesting there might be a way to create an informal result that gets us to a better position than that formal result. Other questions? Anything you wanted to add on that, Sarah?
No.
No, good. Rock and roll.
I just want to add something.
Yes, sir.
In backtracking just a little bit, going back to electronic devices.
Yep.
We just received a new handbook, when we, became either incumbents or new board members. And in there, it does state specifically that supervisors shall not use their electronic devices during a meeting, i.e. like texting, etc. So if anybody is not aware of that, I just wanted to make everybody aware that we should not be using our electronic devices during meetings.
I think that's a good point. It's a good rule to have on the books. I've been in, believe it or not, I've been in committee meetings in counties, not Rusk County, all right, not here, but I've been in a committee meeting where an issue would come up for a vote, one of the committee members would roll back in the chair, pull out his phone, say, here's the issue, how is it that I should vote? Okay, got it, thank you. I'm calling people to find out how to vote on an issue. I'm like, how in the world are you doing your job? Honestly, I could sit here and fill your afternoon with interesting stories in county government that I've learned over the last 30 years, and then Sarah could fill your evening, because there's weird stuff that goes on out there. But remember, you're here because you're representing the electorate that put you in these seats, and you're speaking for them, their voice in county government. I take that responsibility very, very personally, and it's a very important responsibility, and I think you all should too, and I think for the most part, county supervisors around the state do. But let's just do our best to uphold the law, do our best to fulfill our obligations, and I will defend you every single day when you make those decisions in good faith. That's my pledge. I'm not always gonna win, I don't win every single circumstance, but I will defend, and we will defend each other every single day if we act in good faith. All right, anything else? We ready to talk about board rules? This is the fun. I know everybody's been waiting at the edge of their seat saying, when is he gonna talk about board rules? When are we finally gonna get to the really, really good stuff? Is that what everybody's been thinking? I heard somebody mention school board before. Are you on a school board, sir? How long have you been on a school board?
Off and on for 18 years.
Which school district?
Ladysmith.
Ladysmith School District. Does Ladysmith School Board maintain board policies?
Yes.
From where do you purchase them? Neola? Wazi? Neola. All right, and so how many policies does your school board have?
You're kidding.
No, I'm serious. How many policies do you have?
I don't know.
There's a 9,000 in the series, isn't there? It's
Yes.
1,000, 2,000, 3,000, it goes 1 through 9, and then thousands, and then underneath those thousands, I used to do a lot of work with school
Way
districts, so I
less
know
than
this.
people who listen to the town.
There you go. And so when we compare the rules that apply in the school district setting to the rules that apply in county government, are you just amazed sometimes at the difference?
It's mind-boggling.
It is mind-boggling. Because I think about it and I say, okay, we've got county boards that fulfill the legislative function of county government. How big was your budget last year? Operating budget for 2023. How much was it? Ashley, you know this off the top of your head. How much?
Well, let me ask, or, so mid-50s?
Levy plus all other source.
Like mid-50s, like $55 million.
$55 million organization. How many employees do you have?
300-ish.
300 employees. $55 million operating budget. We don't have policies governing our operations. And we still have confusion about our operational construct. That's mind-boggling. In school districts, if we go over there, I'm sure that the school district of Ladysmith, you don't have a $55 million operating budget.
12.
$12 million. Do you have a CEO?
Well, superintendent.
Oh, so the law mandates that you have a superintendent. 118.24 makes clear that you have to have a superintendent in a school district. We don't have to have that in counties. And so, again, this is an example of how the legislature has created a set of rules for county government that don't apply to other layers of government, and in particular school districts. Now, I think there are things that counties do much better than school districts, but from an organizational standpoint, there's a lot more clarity in the school district world about how their board operates, how their superintendent operates, and how their staff operates. It's absolutely clear. And the reason it's clear is that not only do you have statutory guidance, but they have board policies that govern the relationship, and this is the important part, the relationship between board and staff and among the board members, all right? And so one of the ways that we can institutionalize from a governance and organizational standpoint how it is that we interact with each other, with our staff, and with the general public is through county board rules. And I know.
Can I make a point though?
Yeah, no, absolutely. This is an open discussion.
We still deal with, board members that have some of the same challenges as, county board supervisors. with
Absolutely.
Working too many levels down from their job.
Absolutely.
And it's a constant fight to push back on that so that we don't,
And bring it back up to the board level.
yeah, so that we're working on, we're working on the right level. Because people wanna work at different levels because something bugs them and they wanna go fix it, and it's not their job to fix it.
Well, that's a great point though. That's an awesome point. I wanna fix it, but it's not their job to fix it, all right? And I think that's the struggle.
It's
Is
their
that,
job to manage the process.
but I look around this room, and I made the joke before about you all working for the paycheck. I've seen your paychecks. Why in the world did you take this job? Honestly, why'd you take this job? You didn't do it for the money.
Beer money.
Beer money, there you go. You did it because you want to represent the people in your district. You did it because you have a love for Rusk County government. And so oftentimes when we have that desire to represent people and we have a love for county government, we view our role as fixing stuff. We want to get stuff fixed. That's our job. Our constituents have a problem, I'm gonna fix that problem, I'm gonna make sure my people are taken care of. All right, but as soon as we start doing that, we run into problems. Unless we realize what the appropriate role is for us as county board members. And I can guarantee you that at least sometimes, and many times I would hope, the discussion comes back to board policy to say, how is it that we, as a board, have decided, being proactive in policy, how we're going to resolve a particular issue. Yeah, that should happen. It should happen. And so I'm gonna pick on Mr. Willingham for a moment here too, because he and I go way back. I don't know if you all know this, but he and I, we started our relationship probably in the mid-2000s when you were chair of Northern Bridges. And we went through policy governance together in terms of the way that Northern Bridges as an entity, as a long-term care district, was going to govern itself. And if you look at policy governance from a Carver standpoint, Jonathan Carver was an individual who wrote a whole complex series of rules surrounding policy development and procedural development for school boards, primarily at the time it was in Iowa, but it's been called the Carver Policy Governance Model. Now, I personally don't think that you can implement something like that in totality in county government simply because there are too many statutory responsibilities that conflict with the Carver model, but the principles are very important. The principles are here are the things that we're going to address in policy so we don't have to constantly have these questions, every 2 years have a debate about the role of the board, and every so often have a discussion about who makes what decision when and where. And so the Carver model speaks to the relationship between board and administration, speaks to the relationship among board members and things of that nature. County board rules can do that same thing, all right? And so I'm really encouraging counties, WCA is really encouraging counties to take a look at this concept of board rules. How can we make your job easier? Because if we can set it and forget it, and that's the law going forward, we don't have to worry about complex training every 2 years to get everybody up to speed. We already have them up to speed by virtue of the adoption of our board rules. And so I don't mean to get into a detailed discussion of board rules today, because the beauty of board rules is that you get to decide what they say. There is no perfect model. There is no statutory requirement as to what's contained within board rules. You get to say what those board rules say. And when we look at the importance of these board rules, they come right after state law. So it goes federal law, state law, local ordinance, Robert's Rules of Order, and then custom and practice. All right? So when we talk about what the outline of what can be addressed in board rules, we talk about the officers within county government, we talk about organization of the board, And then we talk about procedural rules that the board is going to follow for its meetings and committee meetings. And so I just pulled the table of contents out of the set of board rules that we adopted in Richland County recently. And Richland County called me in November, December last year and said, we need help with our board rules. Our board is really interested in providing better organizational form within Richland County. I said, I'd be happy to help. Took a look at their current board rules, and typically what I do with a current form is redline my changes against that current form and say, okay, here are the changes I'd recommend. I took a look at their board rules, I said, scrap them. Let's start from scratch, because these board rules, they don't make a lot of sense, they're not organized well, people don't understand what they do, and every meeting you're gonna have people flipping through the board rules to figure out what to do. That's not the purpose of board rules. Let's start from scratch. They said, sure, we'd love to do that. It was a tremendous investment, just not only in terms of my resources with that project, but also in terms of the board involvement with several meetings to get up to speed and understand exactly what we were trying to accomplish with the board rules. Throughout that process, I had conversations with Sarah. I said, you know what? I'm finding this discussion in Richland County to be incredibly beneficial. People are asking awesome questions, and they're actually deciding how it is that they want to operate now and into the future, not just for this current board, but for future boards. It's awesome. It's a great discussion. And Sarah said, how can WCA help? We want to help with this. And so that's where WCA stepped up, assisted financially Richland County through that process, and ultimately took the Richland County board rules, and where Richland County made certain decisions within their board rules, we identified those decision points and said every county is going to have decisions to make, because you're not going to want to do things the same as they do in Richland County. You don't, and you shouldn't. You're different than Richland County, and that's awesome. So we came up with this template set of rules. And so I pulled the table of contents from that template set of rules just to give you an illustration of the different topics that you can address within your board rules. What's the purpose of doing this? It's to show you a preview of what could be to get you excited about the end product. And the end product being a set of board rules that allow you to operate as a county board with full comfort that you're being proactive and visionary in your approach to governance. So we've got purpose and definitions and interpretation within the board rules. We get into county board organization. We speak to meetings. We talk about agenda responsibilities. We talk about committees. We talk about committee agendas and so on. Who's responsible for what decisions, when, and where? There's never a question about that if we have board rules like this. As it relates to committee structure, that's another conversation that Sarah and I have been having with many counties across the state is, what's the appropriate number of committees for a county to have? How many committees do you currently have? Standing committees of the board? In fact, you don't know that off the top of your head is a little bit troubling.
Well, we have 13, but we have so many
13 standing committees, and how many subcommittees? Another, I don't know, 5, 6, 7. Okay, so we have over 20 committee-related responsibilities. How many people find that an easy system to navigate? It's simple. It's pretty straightforward. We know exactly what committees are doing what, where. All of that pretty simple, right? And a lot of counties are having that discussion. I was just in Juneau County earlier this week having this discussion about committee structure. They have 27 different committees, all right? And so they're saying, we don't understand. In fact, it was the personnel committee where they said, where's the job description for the personnel committee? I don't know what I'm supposed to do. Wait, what? You're the chair of the personnel committee. This is kind of a problem, all right? So Juneau County said, let's take a look at our committee structure and see how we can simplify it. It's not reducing it for the sake of reducing it. Sometimes reduction isn't a good idea. For example, in the mid-2000s, we had a big push from the outside and various interest groups to reduce the sizes of county boards, thinking that would promote efficiency. I don't think it promotes efficiency. Frankly, I think that sometimes, I think your board is a good size, but sometimes you get too small and you're just not able to do the things that you need to do from a policy development perspective with that few number of people. So I prefer a board this size over a board of 11, for example, as it relates to county government. So reduction in size isn't always the push or the right answer. What we're looking for is efficiency. And so what we did in Richland County is reduce their standing committees to 5, all right? There are additional committees, statutory or otherwise, that have specific responsibility that work with one of the 5 standing committees to get information or recommendations, resolutions, ordinances to the county board, okay? And so the 5 committees, don't think of everything being consolidated into 5, but all areas of county government and responsibility within county government go through those 5 committees. And some people have said, well, wait a second. By law, you have to have a zoning committee, you have to have a human services board, you have to have a highway committee, you have to have parks and recreation. All of these different things, you have to, by law, have at least 12 committees. I made that number up, but at least that number of committees, because that's what the statutes identify. Well, yes and no. You have to have those committees, but there's nothing in the law that says you can't have one committee with those various responsibilities. So you can look at that. So what we did in Richland County is we reduced the number of committees, created the 5 standing committees, created the opportunity for those other committees and commissions and boards to report to the county board through those other committees. And I know that within the next 3 months, somebody is going to say, this doesn't make sense, we need to move these pieces around. So with the committee structure, we created what we called Appendix A to the board rules, which was the committee structure. So that if we needed to modify the committee structure, we could modify the committee structure without having to reopen the board rules and amend those board rules by supermajority vote. All right, we wanted to maintain some flexibility there. Now, they're still rolling it out in Richland County, and we'll see how it goes. I don't know, it's only been a couple of months here into the new term, but I can tell you my work with La Crosse County, Ozark County, any other counties where you can think where there was committee reduction in size? I didn't work with Washington County. Sauk just did that. Really, really positive feedback. They said, look, it is so much simpler to figure out exactly what belongs where with our new committee structure. And it is so much easier to focus on policy development within those committees, because if we get involved in operations, we're in meetings for 3, 4, 5 hours. Nobody wants to do that. So I've heard a lot of positive feedback on doing that. I'm not saying you have to do that, you don't. You may like this system here, and if it works, stick with it. But if it's something you want to look at on creating an efficient form of governance and an efficient organizational form, then absolutely take a look at board rules like this to help you along the way. County board officers, we talked about that briefly. And then we've got rules of procedure. Now, your default is Robert's Rules of Order. And Rules of Order, newly revised, 12th edition, is the current version of Robert's Rules. If you have no procedural rules governing the board, your procedural rules are Robert's Rules of Order. All right, that's what you have. I will tell you that there are things in Robert's Rules that I don't think work well in county government when it comes to county boards. I think we need to look at that. And so that's why we have these rules of procedure, because we want to modify what Robert's Rules says. And Robert's Rules even says you have the ability to adopt your own rules that are contrary to the rules here in Robert's Rules. So you have the ability and the freedom and flexibility to adopt rules of procedure as you see fit. And so you'll see in here, I like to put in the board rules things like remote attendance at meetings. Robert's Rules says you can't attend a meeting remotely unless your local rules allow you to do so. State statute is silent on this. So in the absence of a rule, who can zoom into a meeting? Nobody. Nobody can. All right? So let's have a board rule that identifies the boundaries of what we will accept in terms of remote attendance at meetings. Order of business. I think there ought to be regularity both at the board level and the committee level about what an agenda looks like, what's going to appear on an agenda, what type of business are we taking up. And so let's put that right into our board rules and so on. We deal with that all throughout these board rules. So again, I didn't get into the details, but I do think that you would at least enjoy a discussion about whether we can update our board rules, whether that would help the process, whether we can perhaps reduce the number of committees, whether we can perhaps enhance the level of detail about what each committee is involved in to ensure that we don't have conflict and opportunity for discord and ambiguity about who's doing what, when, and where. I think you would enjoy the discussion about defining the relationship with your administrative coordinator and staff, having a discussion about committees of jurisdiction. So I would again encourage you to do this. And I will say that if you want help in that discussion, Sarah and WCA, we'd be happy to help you with that discussion, because after all, I think everybody is better served by a high-functioning county government, whether it be Rusk County or any of the other counties in the state. So WCA is willing to assist in that regard. So let us know how we can help. Let me pause there. Any questions, comments, discussion points?
I know Price County did that, they reduced their number of board members.
Price County.
And they, my cousin was on there, and she said that the districts got so big that the constituents didn't know who they were, they would run into them in the store, and they seemed to have lost contact with people that they were representing.
Yeah, that's exactly an example of sometimes a smaller board size isn't always better. That's exactly right. Price County's kind of big too. There are some districts that represent a lot of trees. So, other comments or questions?
How many board members, this one's for Mr. Willingham, but how many board members were there in Rusk?
In Northern Bridges?
No, in Rusk County, how many board?
Oh, how many were there?
At one time, yeah.
Oh, I don't know the answer to that. Do you know the answer to that, Dave? How many board members did
39.
Was it 39?
I think originally it was the town board chair from each town
Yeah, maybe.
and all members of the city council were the original county board back in probably, I think that changed in the early 70s.
Yeah, that sounds consistent with my understanding of the way counties used to operate. Yep.
So my next question would be is, when did we change our territories the way they are now, the way they're cut? Cause I got a big district, the northern half's a big district, when did all that change to?
I think it went from 39 to 21 back about that time.
Okay, so it's been in play for a while then.
And then it went from 21 to 19, probably maybe in 2003 or 4, something along that line.
It would have been consistent with when other counties took a look at that issue, because there was a
Actually,
push to reduce.
I think that the rationale for going from 21 to 19, to be honest with you, there was some activity in the county where the citizens can petition the board to, and require them to redistrict and change the number of districts. And the county at that time thought they would preempt that by just going from 21 to 19, and that's what they did.
It does preempt. You know, I joked about it at the very beginning of our discussion, Marathon County with 38. They went from 39 to 38 to circumvent a citizen-led petition to reduce them even further. That's right.
Good to know.
There you go. There you go. Now you know. Other questions or comments? I don't know if I wanna put Ashley on the spot and see if she has any comments on board committees and things like that. I mean, I imagine that from your perspective, it can be at times confusing trying to figure out, is this a decision that has to go to a committee, and if so, which one?
I would say it's confusing for all department heads, what needs to go to oversight committees, then what needs to be forwarded on to different committees. Things change from committee to committee, then do certain committees want that back to them before it goes to the board? It's just, it's growingly confusing, I would say.
This is an open meetings question.
Go for it.
This body's been struggling for several years with the sound system in this room. And someone like yourself can be heard by everyone in the room because you have that kind of a voice. There's always summing up to the jury or whatever, but many members of the board do not have voices that carry well. And so the location of the microphone, which I think is somewhere over in here, is not conducive to every board member being well heard. And if board members can't hear each other, and it is particularly a problem when we have a committee meeting and the committee sits around the table, people in the audience are not able to hear. So at some point, it's not an open meeting if everybody in the room can't hear. You know,
At some point it does become a problem, that's right.
And,
That's right.
and then the other thing, which I know is something we unconsciously do sometimes, and that is, the meeting is going on, committees, I'm probably more on a committee meeting than a board meeting, but something pops into my head and I lean over to Mike and say something to Mike. If everybody in the room can't hear what I'm saying, we're not in a public meeting or an open meeting then.
Yeah.
So, I don't know how we police ourselves to make sure we're doing that, but, particularly, I still think, and I think we spent some more money trying to fix the system, the sound system, and it still doesn't work.
I don't know if any money was spent on it.
Individual microphones would be very helpful, I think.
Well, and I mean, that folds into the discussion about decorum and expectations on the county board. I like to elevate the conversation with the county board. It's very important stuff. I mean, again, this is a very large organization, and so you're the board of directors for a very large and complex organization. And so I would want our board meetings to be an exemplar of how the best board of directors in the entire county and region operates. And so we ought to operate in a very formal capacity in terms of our interactions. We're not having side conversations during meetings. We're speaking so that people can hear. We're doing things in a way that instills trust and faith in the public because we're taking care of their tax money. It's an awful lot of money that they give us. And so I love to see board rules that instill a level of formality and decorum in board meetings so that everybody understands the importance of the business that we are undertaking here, all right? So different counties do it different ways, and I'm not here to suggest that everybody has to put on a three-piece suit to come to a board meeting. That's not my point. My point is simply that we treat the seat that we're in with the dignity, honor, and respect that I think it is deserving, and I think all of you think it is deserving as well. One of the ways that we can instill that type of culture is through our board rules. Other points? That's it. That's all we got for the formal presentation today. It's awesome that you guys stuck with us for 3 hours and 15 minutes. I know the pizza was here to bribe you to stay longer, so that's an added incentive. Thank you for that. But again, if you find yourself going down this discussion point of saying, you know, I think we want to look at our board rules, or we have additional questions on this, or what, we're a resource. WCA, we're resources. Feel free to reach out to us. And there are additional opportunities outside of these individual meetings with Rusk County. We have an annual conference coming up in September in La Crosse, and there is going to be, we didn't touch on parliamentary procedure here today, but there is going to be a 3-hour session on parliamentary procedure, 1 hour of which is going to be basic fundamental discussion, and 2 hours of which is a mock county board meeting where there will be plants that are there to raise parliamentary procedure issues. Last year we did it for 1 hour. We ran out of time and said we're going to do it for 3 hours. And it was a blast. I mean, people are still talking about that meeting. It was so much fun. Sarah will make an appearance at that meeting. She will have a role and she will play it very well. So that's the teaser. I'm the county clerk, so I don't have much responsibility at that meeting. I can say that because county's not here. So it's a blast. It was really fun. Point being is that in addition to that breakout session, there are a lot of other breakout sessions on really good topics at that conference. An example of additional opportunities to get additional insight on county government operations because there's no manual out there. Well, there is. Now we have the handbook. Did you send the handbook out to everybody? You did. So you got the handbook. But I mean, this is a tough job. It really is. Let me ask this. How many of you got a job description when you went to take out papers, nomination papers? How many of you got a job description to be on the Rusk County Board? Oh, so how did you know what you were signing up for? How many of you sat in the seat for the very first time and say, what the hell did I just do? Yeah, right? And I have this conversation with counties a lot too. I'm like, why don't you take your job description, your board rules, your strategic plan, your budget, put that in a stack of papers so that when people come and take out nomination papers, you hand it to them and say, here you go. And they say, well, then nobody would take out papers. Okay, so you're going to trick them to get in that seat and then tell them what the real story is. It's tough. I get it's tough. And so whatever resources we can help provide, we're happy to do it. All right. Thank you guys very much.
Thank you.
All right. That's it.
That's a wrap.
That's a wrap. You got some leftover pizza.
You a rapper? I'm a rapper. That's a wrap. That's all there is.
Motion to adjourn.
Oh.